Millet, conviction 4 years in the PC Act in custody Millet and rate of judgment. Monday Millet.
Well, this matter received to the DLS Sundargarh matter is appeal against acquittal.
Yeah.
I may be pardoned. Appeal against conviction is on interim bail.
Give it.
Due to exam. And one more tied up matter. Grateful.
It's a tied up matter.
Give it.
And I am pardon to mention to vigilance office for hearing. In one DA case, only 1 lakh. If it is taken to the father.
No, but what is the year of that appeal?
2009, what 2013.
Okay, we'll give you.
Another one is in the list, item 45. The appellant is left 5 years, 5 months service. He is in out of job.
No, there are two pattern matters. After finishing this, then I will proceed to that.
Okay.
Yes.
Fresh CRLA 829 of 23. Fresh admission.
Fresh admission. Give it.
I want to make a mention, BLAPL number 3889 of 2023, there was specific adjourn on 15/5/2023. It was on list, but did not reach.
All right, give it.
Millard, the Honorable Court has ordered for posting this case on 6/3/2023. The CRL MC case. But after and also could order that to file a consolidated cause title.
CRLMC is not assigned to me. CRLMC is not assigned to me. Now it must be assigned to some other bench. Please make a mention before appropriate bench. Yes.
I may be pardon to mention, I have filed an CRLMP challenging the order passed by the family Kujos.
Give it.
I may pardon to mention lordships.
Yes.
Weekly list 70, hearing item 73, your lordships.
Yeah.
The petitioner has been, appellant has been convicted under section 2BC NDPS Act, your lordships, for 10 years and 1 year for fine, your lordships, for fine amount 1 lakh. Your lordships, your appellant has already more than 8 years undergone, your lordships. So
let me finish these two part-hard matters. Whosoever present, I will take up the case. Okay.
May I pray, your lordships? I have filed a bail application, lordships. May I pray it will be taken by the authority for orders, your lordships?
Okay. What is that item?
Item 73, your lordships.
73 to weekly list of the bail matter. Yes. Madam, please unmute yourself if you want to make a mention.
Pardon to mention item 4, my lord. I pray for next week conducting arms.
What do you want?
Next week, my lord, conducting arms is suffering from.
They are in the list. I will go from 1 to in this way. So get ready. I will. Yes.
Pardon to mention, my lord, lordship granted bail, my lord. Criminal appeal 832 of 2017. I had not filed for fine realization of fine.
Give it. It will come next.
Another, my lord, appeal, my lord, UTP appeal, my lord, SCST.
Okay. Give it. Yes.
Weekly list item number 1.
Yes.
Item 33. It's a appeal against acquittal. I am entering appearance today. Milords, I am 61. My retirement benefits have been withheld. It's appeal against acquittal of the year 2003, 93.
Vigilance matter.
Yes, vigilance matter. What I pray for, Milords, if your lordship can fix it to the top of the list next week so that they can be aware of.
What is the item?
33, Milords. Here, Milords, the complainant and the overhearing witness turned hostile.
It's all right. Where is your wakalatnama, Mr.?
I'm appearing today. That's why I'm saying on next Thursday, Milords.
You file the wakalatnama, we'll pass the order.
Just now, Milords, I am filing.
You're filing? Pass person. Mr. Rijvi, this GCRLA, it's a vigilance matter. It's a who is to
Mr. Sangram Das will be conducting this matter. I will inform him.
Tell him. It's a acquittal order, and he says that both decoy and overhearing they have gone hostile. So
nothing is there.
Mr. Devasi Sarangi and his associate file power. for the respondent after obtaining no objection from the earlier engaged counsel. Wakalatnama is taken on record. The name of Mr. Sarangi and his associates shall be reflected in the cause list as well as in the top of the brief in place of earlier engaged counsels. Since paper book is ready and the matter is of the year 2003 and it is stated by Mr. Sarangi that in spite of acquittal order, the pensionary benefits of the respondent has been withheld by the department.
Partially.
Matter be, yes?
Partially withheld.
Partially withheld. The matter be listed in the top of the list after the part matters next week. Yes.
Obliged.
Playlist item number 1.
Please, Your Lordship.
Paper book follow. Just a minute.
Lordship, the appellant here has been convicted.
Wait.
Yes.
Your good name is
Satyasmati Mohanty, my lord. S.S.
S.A. Tell the full names.
My lord, S.A.T.Y.A.
S.A.T.Y.A.
Middle name is S.M.R.U.T.I.
लगेगी नहीं.
नहीं, अलग अलग.
S.M.
R.U.T.I.
Smruti. Satya Smruti.
Mohanty. M.O.H.A.N.T.Y.
Paper book hai. Okay. Come to the charge first. Come to the charge.
My lord, page 42, my lord.
Yeah, read it out.
I, Sri S.K. Pradhan, BSc LLB Special Judge Vigilance, Barampur, hereby charge you, Dr. Pradipta Kumar Praharaj, as follows. That on 14/9/98, you being a public servant employed as Assistant Surgeon, Project Hospital, Khattiguda, District Nabarangpur, obtained for yourself pecuniary advantage to the extent of rupees 300 from the complainant, namely Gajendra Naik, by corrupt or illegal means, or by otherwise abusing your position as such public servant, and thereby committed an offence
Complainant has been
punishable.
examined as PW.
My lord.
Complainant has been examined as
My lord,
PW.
PW 5.
Okay, read it out.
Yes.
Then, secondly,
Yes, ma'am.
Charge complete. 42.
page 42.
Yes, Your Lordship. As such, public servant and thereby committed an offence punishable under section 13(1)(d) of the PC Act, punishable under section 13(2) of the said Act, and within my cognizance. Secondly, that you on or about the same date, time, and place, being public servant as aforesaid, accepted from the complainant Gajendra Naik an amount of rupees 300 as gratification other than legal remuneration as a motive or reward for doing an official act, that is for issuing his medico-legal opinion in respect of injury of the complainant and thereby committed an offence punishable under section 7 of the PC Act and within my cognizance, and I hereby direct that you be tried by this court on the aforesaid charges.
So these are the two charges.
Yes, Your Lordship.
Now, what the learned court found guilty under which offences, or both the charges?
Both the charges.
Okay. Come to that operative part of that judgment.
Your Lordship. Your Lordship, page 24.
24, okay.
Para 31, just the operating portion.
Yes.
In view of the above discussion and finding, it must be held that the prosecution has established the ingredients of offences under section 7 and 13(1)(d), read with section 2 of the Prevention of Corruption Act against the accused. The accused therefore is found guilty under section 7 and 13(1)(d), punishable under section 13(2) of PC Act, and he is convicted thereunder.
Okay. Now you come to the FIR.
Yes, Your Lordship. So page 37. My Lord, has it?
Yes.
Yes. ମୁଁ ଶ୍ରୀ ଗଜେନ୍ଦ୍ର ନାୟକ, ପିତା କୁମାର ନାୟକ, ଗ୍ରାମ ବିନକମରା, କମାର, ଥାନା ଥୁଆମୁଳ, ରାମପୁର, ଜିଲ୍ଲା କଳାହାଣ୍ଡି, ଲେଖି ଜଣାଇବା ଅଭିଯୋଗ ଏହିକି ମୁଁ ଗତ ତାରିଖ 23/8/1998 ରବିବାର ଖାଟିଗୁଡା ଥାନାର ଗ୍ରାମ ଉପରଗୁଡା ଗାଁକୁ ବନ୍ଧୁ ଘରକୁ ଯାଇଥିଲି। ସେଇ ଗାଁରେ ପ୍ରଭୁଦାନ ହରିଜନ ପିତାମ୍ବର ମୋର ସାଥିରେ ଗଣ୍ଡଗୋଳ କରି ମତେ ଗୋଟିଏ ଥେଣ୍ଟା ବାଡିରେ ମାରିବାରୁ ମୋର ଡାହାଣ ହାତରେ
ବଡ କ୍ଷତି ହୋଇଗଲା।
ବଡ କ୍ଷତି ହୋଇଗଲା, କ୍ଷତି ହୋଇ ବହୁତ ରକ୍ତ ଗଲା। ଏଣୁ ମୁଁ ଥାନା
ମୋ ଦାଦା ଡମ୍ବୁରୁ ନାୟକ,
ମୋର ଦାଦା
ଥାନା ରିପୋର୍ଟ ଦେଲି। ମତେ ଥାନାକୁ ଖତିଗୁଡାରେ ଥିବା ପ୍ରୋଜେକ୍ଟ ଡକ୍ଟରଖାନାକୁ ଚିକିତ୍ସା ପାଇଁ ପଠେଇଲେ। ସେଠୁ ଚାକିରି କରୁଥିବା ଡକ୍ଟର ପରାଜଙ୍କୁ ଡାକ୍ତରଖାନାରେ ଜଏନ କରିଥିଲେ। ମୁଁ ଚିକିତ୍ସା କରିବା ପାଇଁ 500 ଟଙ୍କା ଦାବି କଲେ। ମୁଁ ଗରିବ ଲୋକ, ପଇସା ପତ୍ର ଏତେ ଦେଇପାରିବି ନାହିଁ ବୋଲି କହିଲେ ପ୍ରଥମେ 100 ଟଙ୍କା ଦାବି କରିଥିଲେ। ବଳକା 400 ଆଉ 4-5 ଦିନରେ ଯୋଗାଡ଼ କରିବାକୁ ପଡ଼ିଲା। ମତେ 11 ଦିନ ଡାକ୍ତରଖାନାରେ ରଖି ଗତ 16 ଦିନ ଡାକ୍ତରଖାନାରୁ ଡିସଚାର୍ଜ କଲେ। ସେଇଦିନ ଡାକ୍ତର ପ୍ରହରାଜ ବାବୁ ମତେ ବଳକା 400 ଟଙ୍କା ନଦେଲେ ତୋ ଡାକ୍ତର ସାର୍ଟିଫିକେଟ ଥାନାକୁ ପଠାଇବି ନାହିଁ କିମ୍ବା ତୋ ଦେହ ପୁରା ଠିକ ନ ହେବା ପର୍ଯ୍ୟନ୍ତ ଚିକିତ୍ସା କରିବି ନାହିଁ ବୋଲି ଧମକ ଦେଲେ। ମୁଁ ତ ପଇସା ଦେଇପାରିନି ବୋଲି କହିବାରୁ ଅତି କମରେ 300 ଟଙ୍କା 16 ଦିନ ଦେବାକୁ ଦାଲିକା ନଚେତ ତୋ ବିରୁଦ୍ଧରେ ସାର୍ଟିଫିକେଟ ଦେବି ବୋଲି ଧମକାଇଲେ। ମୁଁ ଅନ୍ୟ ଉପାୟ ନ ପାଇ 300 ଟଙ୍କା ଯୋଗାଡ଼ କରି ଆମ ଡାକ୍ତର ପ୍ରହରାଜକୁ ଲାଞ୍ଚ ଆକାରରେ ଦାବି କରୁଛି। ମୋ ଇଚ୍ଛା ବିରୁଦ୍ଧରେ ମୁଁ ତାଙ୍କୁ ଟଙ୍କା ଦେବା ପାଇଁ ଯାଉଛି, ତଦନ୍ତ କରି ପ୍ରତିକାର ନ ଦେଉଛି। So the one incident took place on 23/8/1998. So
He was in hospital for 11 days.
5 referred to Project Hospital, Hattiguda. Discharged on 4/9/1998. Initial demand ₹500. Paid 100.
Yeah, yes, ma'am. 100. And after discharge,
Balance amount reduced to ₹300. Date fixed for accepting
14
bribe 14/4/1998. Okay.
Malad, I just wanted to rely on what he has said here is 400 ଟଙ୍କା ନଦେଲେ ତୋର ଡାକ୍ତର ସାର୍ଟିଫିକେଟ ଥାନାକୁ ପଠାଇବି ନାହିଁ କିମ୍ବା ତୋର ଦେହ ପୁରା ଠିକ ନହେବା ପର୍ଯ୍ୟନ୍ତ ଚିକିତ୍ସା କରିବି ନାହିଁ. So my lord, he is talking about injury report. Injury report ଥାନାକୁ ପଠାଇବି ନାହିଁ. Sixth line from the top.
Come to the accused statement.
Yes, sir. Page 60, your lord. PW5.
So it is first question answer is yes.
Accused statement. I'm sorry.
Accused statement. First question answer is yes.
Yes, sir.
You are serving. Okay.
44.
Then leave it Janini. Come to question number 10.
Yes, your lord. Further, it transpired that about 12:10 a.m. on getting pre-arranged signal from the accompanying witness, the trap party members.
Just a minute. Pura kato. Yes, question number 10.
Yes, Your Lordship. Further, it transpires that about 12:10 a.m. on getting pre-arranged signal from the accompanying witness, the trap party members rushed to your office room where you were sitting on your chair and the complainant and his brother were standing near the entrance door of your office room. What do you have to say? True. 11. Further, it transpires that after getting confirmation from the complainant and his brother and accompanying witness, The trap party members challenged you to have demanded and accepted the bribe amount from the complainant, to which you denied the same. True.
Just a minute. So question number 10 is further transfer at about 12:10.
Yes, sir.
That on getting the pre-arranged signal, the accompanying witness, the trap party members rushed to your office room where you were sitting on your chair, and the complainant and his brother were standing near the entrance door of your office room. True.
Yes, sir.
Then further it transpired that after getting confirmation from the complainant and his brother and accompanying witness, the trap party members challenged you to have demanded and accepted the bribe amount from the complainant, to which you denied the same. Okay, true. Then
12 is further it transpires that the informant kept the demanded amount on your table as per your direction, and thereafter you wrote down the medical certificate and handed over the same to the informant, Micha.
Acha. Then the next question, it further transpired that
Your hand wash was taken and tested in the solution of sodium carbonate separately, but there was no change of color of solution, and the samples have been preserved for chemical test. True.
that your hand wash was taken and tested in the solution of sodium carbonate separately, but there was no change of the color and the samples had been preserved. True. Okay. Then
it further transpires that when you denied to have demanded and received the bribe amount, a search was conducted as per the version of the complainant and his brother, and the tainted GC notes were recovered from inside the table calendar kept on your office table, and the official witnesses compared the notes, numbers, and initials which tallied with their earlier noting.
so the place of recovery of tainted note is the table calendar.
Yes. Table calendar kept on the table of the accused.
Your hand wash did not change any color. None of the hand wash.
None of the hand wash. And my lord, this is corroborated by the IO and also the witness present, my lord.
What about the C report?
C report is positive. C report is positive. That is the basis on which the learned lower court has based its conviction.
Page 77 is the SFL report, where it confirms that the hand wash has come positive. Material objects 4 and 5.
The hand wash mark is kete?
MO 4 and 5.
4 and 5.
Page 77, your lordship may kindly. That is the report, my lords. Last but one page of the paper.
No, this
result of the examination. Your lordship got it, my lords?
No, it's all right, but I come to page number 75. 75 कोटा mark हला कौन?
Page 66 ଅଛି ସେଟା।
75 ତାର ତିନିଟା ନମ୍ବର ସେଠି ପଡିଛି, ଗୋଟେ 118 ପଡିଛି, 75 ରେ ସେ ଯୋଉ କେବଳ ଗୋଟେ ତା ଦେହରୁ କଲର ଆସିନି, philanthropy 9 ସେଟା ହଉଛି ନମ୍ବର 1 ଯୋଉଟା 1 ଟାକୁ ମାର୍କ 1 ଟା ହଉଛି ଆମେ ଯଦି 75 କୁ ଆସିବା ସେ ହଉଛି hand wash of the witness.
Yes.
ତେଣୁ ସେଇ ଗୋଟାକରେ ନାହିଁ.
It is of the witnesses, my lords.
Okay.
Not of the
आर हला
4 and 5.
At the time of detention of the trap, yes, the hand was finger the right hand of the accused. No, that is 3 and 4. 3 and 4.
3 and 4, yes.
3 and 4. Detection the trap handles of the fingers also. And then calendar was 5.
That turned even in naked eye.
CE report is more authenticated than the naked.
No, that color is so powerful. The moment you wash it, it will change
The
to
color.
pink color. So that is why that particular powder is used, and sodium carbonate solution is used to wash the hands.
Ma'am.
So it can be very easily seen that it's like rose flower color, that pink color. It comes. So
But the fact remains,
what happens that because it is your case also, that perhaps that is why the questions has been put, that it did not change any color. If you come to the accused statement,
Yes, sir.
yes,
that accused statement is at page
page 40.
42. It starts from page 42.
No, 63. Running page 63. Inside.
So
Lordship is referring to question number 13.
Question number 13. It further transpires that your hand wash was taken and tested in the solution of sodium carbonate separately, but there was no change of color solution, and the samples had been preserved for the chemical test. So this must be the evidence of the IO.
Yes, sir.
That with the IO.
PW 6.
6.
Yes.
Let us come to that.
Yes, sir. Page number.
Say portion
Again, page number 64. It starts. My lord, may kindly come to para 2, page number 66. Page 66, para 2.
Yes.
Lordship has it. Should I read, man?
Yes.
After some time, getting signal from the accompanying witness, we all proceeded to the spot. The spot is the room of the accused doctor. After reaching the spot, I myself gave my identification and identification of the witnesses and asked him if he has received the bribe from the complainant. At this, the accused denied to have received the money. Thereafter, being told by me, ASI K. Mohanty prepared chemical solution of sodium carbonate and kept the same in 2 separate glasses. Thereafter, being directed by me, the accused dipped his right hand in 1 glass of solution and another hand in another glass of solution. After doing this test, I ascertained the color of solution in both the glasses did not change. I preserved the sample of solution in 2 separate bottles. Thereafter, I searched for tainted GC notes and found the same from under a table calendar which was lying on the table of the accused. This is the said calendar marked as MO6. Thereafter, as per my direction, the calendar was tested in chemical solution, as a result of which the color of solution changed to a slightly pink rose. Well, clearly...
Wait. Okay, now you come to that very statement. What is your ultimate plea?
Yes, Your Lordship. At the end, man. Question number 23, Your Lordship.
No, question number 19 question.
19, right. Further, page 64. Further, it transpires that a detection report was prepared in your presence and in presence of the trap party members, and a copy of it was served on you, along with the copies of the Caesar list.
ମୁଁ ମଧ୍ୟ ତାକୁ ପଢି ନାହିଁ ସତ, ମୋତେ contents ବିଷୟରେ ଜଣା ଯାଇ ନଥିଲା. Okay. Now you come to the last question. Question number 23.
Do you want to say anything about this case? Well, here is the allegation that counter allegation that he has made, that Gajendra Rao Bhai Tumbhe Barara rehabilitation or resettlement age determination Karibara
ଅଗ୍ରାହ୍ୟ କରା ହୋଇଥିଲା. ମୁଁ
ସେଇ ମେମ୍ବର
ସେଥିରେ ଜଣେ ମେମ୍ବର ଥିଲି, ଏଣୁ ମତେ ମିଛ ଟ୍ରାପରେ କରାଯାଇଛି। ଗଜେନ୍ଦ୍ରର ଭାଇ ତୁମ୍ବନାଥର ବୟସ ରିହାବିଲିଟେସନରେ ସୋ ଡିଟରମିନେସନ କଣ ଅଗ୍ରାହ୍ୟ ହୋଇଯାଇଥିଲା।
Well, this particular committee report is also has been taken on record manner, and DW1 has furnished it.
Okay, now come to the evidence of that PW5.
PW5, yes, Your Lordship. Well, page 60. Shall I?
Yes.
About 6 to 7 years back, I had been to village Uppargudi. At Uppargudi, Prabhudana had assaulted me, for which criminal case was instituted against Prabhudana. I was hospitalized in Kathiguda hospital. I stayed there for 9 days.
No, just a minute. What is that case number which was lost, and whether that FIR has been put? PW5 was stated to be assaulted by one Prabhudana. Criminal case instituted. Hospitalized for 9 days. Rupees 300 demanded to issue medical certificate. So my first query to both of you, that whether that criminal case FIR has been proved in this case.
No.
The requisition which was issued by the investigating officer of that case to this project hospital,
yes,
whether that has been seized.
Yes, Your Lordship.
But is that
my Lord, may kindly see page 34. Exhibit 10 is the injury report.
No.
Exhibit?
My Lord is asking about the requisition that has been sent.
I'm telling about the requisition. Requisition after made by the police to the concerned PS to treat him, and then
to the hospital.
What is that page you said?
No, page 34 was the list of exhibits.
List of exhibits he is pointing out. There
which,
it has
which one?
I'm pointing out Exhibit 10 injury report.
Exhibit 10
injury report.
Just a minute.
Yes.
Exhibit 10 injury report. Okay. Exhibit list of बाहर करो. Trial court record भी जाओ. List of exhibit 10 को आसो. Here on 3, 4, 5, 6, 7. Wait. This is 12. Back करो. It is 11. Out back करो. This one 10 तो नहीं है. 9 এটা হলো. এটা 10 লেখাই. So এটা হলো কোন লেখা হলো ধীরে? Gajendra Nayak Swanso. In sending here with the above noted person, I beg to state that the sage NGO represented on 23/8/1998 at about 8 p.m. one Prabhudan Harijan of village Odi Swanso assaulted by means of a spear and is on his right hand wrist. As a result, he sustained bleeding injury and complaints of pain all over the body. Please examine and opine the cause and nature of injuries at early date. So, Exhibit 10 is the
Injury report.
No, it is requisition.
Yes.
One side is requisition, the other side, Deputy Director, no. It is just a requisition. The भूल लिखा है जी এটা देखी से डॉक्यूमेंट FR पेज होची 51. So it is not an injury report. It's been wrongly mentioned. It's a requisition, medical requisition, dated 24/8/1998. For examination of PW5. So this has been proved. This requisition has been proved. And ना लिखा है ताकू किए मार्थला लिखा है सेतमे रिपोर्ट हेतला भी लिखा है so okay, now the next question is, so the criminal case instituted, it is Exhibit 10 नु जा जना पड़छी बाकी हला so far as his statement that he was hospitalized for 9 days. That means it's as an indoor patient.
Yes.
He has remained. So any bedded ticket has been
Yes,
seen?
Yes,
Exhibit 13.
13.
Just a minute. Exhibit 13 is the
Bedded ticket.
bedded ticket of PW5. Okay. Now let us come to that bedded ticket. This bedded ticket indicates his name has been given and it is mentioned date of admission. Please note it down. Date of admission is 24/8/1998. Okay. Date of discharge
4/9.
28/8/1998.
This is the discharge date, man.
Hey, any of the other khatam. See the top portion, लिखा है cited date of admission, DOA, and ता तले लिखा है date of discharge. এবং କୋଉ ଟ୍ରିଟମେଣ୍ଟ କୋଉ ଦିନ ଦିଆ ହେଇଛି ମଧ୍ୟ ଲେଖା ହେଇଛି ଶେଷ ଏଣ୍ଟ୍ରି ଦେଖନ୍ତୁ ହେଇଛି 28 ତାରିଖ ଦିନର the pora page re.
Yes,
So
28.
he was not available on 4/9/98 in the hospital. He has already been discharged since 28/8/1998. Pass on. So first of all, from this particular documentary evidence, which has been proved by the prosecution, the statement of PW5 that he was hospitalized
for 9 days.
For 9 days, that is that is, what is the date?
4/9/1998.
4/9/1998 is not correct.
Just on that point, madam, in the FIR he has stated 11 day.
Whatever it may be, देखिए.
He has been subsequently declared hostile also.
So date of discharge is
28/9
so and so এবং प्रत्येक दिन एंट्री अच्छी 24 एंट्री अच्छी कौन कौन दिया गला 25 भी एंट्री अच्छी 26 एंट्री अच्छी ऊपर 27 28 लास्ट एंट्री so that was seized. That is your document, is not that so এই ডকুমেন্টটা ইন্সপেক্টর অফ ভিজিলেন্স সিজ ମଧ୍ୟ କରିଛନ୍ତି 14/9/98 ରେ that IO seized it. It is mentioned clearly that
yes ma'am, there is an endorsement ma'am.
Okay, now you come to that evidence of PW5.
Yes, sir. Okay. Page 60. Shall I do?
Yes, continue.
I stayed there for 9 days. I was being treated by the doctor accused. The accused doctor, after my treatment was over, told me to pay 300 rupees to issue a medical certificate in my favor. The accused told me that he will issue a good medical certificate. I did not pay any money to the doctor accused. I told the said fact to Vigilance Inspector. Being told by Vigilance Babu, I got a written report written through one man and submitted the same to the Vigilance.
Wait, just a minute. এটা ধরো পেপার উল্টে দাও এই ଏଭିଡେନ୍ସଟାକୁ ଗୋଟେ ସାଇଡରେ ରଖନ୍ତୁ ଆର ସାଇଡରେ ଏଫଆଇଆର ରଖ ତାର ଏଫଆଇଆର ଷ୍ଟେଟମେଣ୍ଟ ହଉଛି ମୋତେ ଥାନା ବାବୁ ଖାତିଗୁଡାରେ ଥିବା ପ୍ରୋଜେକ୍ଟ ଡାକ୍ତରଖାନାକୁ ଚିକିତ୍ସା ପାଇଁ ପଠେଇଲେ ଓକେ ସେଠାରେ ଚାକିରି କରୁଥିବା ଡାକ୍ତର ପ୍ରହରାଜ ବାବୁ ମୋତେ ଡାକ୍ତରଖାନାରେ ଜଏନ୍ କଲେ
ଏବଂ ମୋର ପୁରା ଚିକିତ୍ସା ପାଇଁ 500 ଟଙ୍କା ଦାବି କଲେ ମୁଁ ଗରିବ ଲୋକ ପଇସା ପତ୍ର
This statement is not there in the court
No, madam,
in
not yet.
deposition he has not. Okay.
No,
ମୁଁ ଗରିବ ଲୋକ ପଇସା ପତ୍ର ଏତେ ଦେଇ ପାରିବି ନାହିଁ ବୋଲି କହିବାରୁ ପ୍ରଥମେ 100 ଟଙ୍କା ଦାବି କଲେ. This is also not there.
not there, madam.
ବଳକା 400 ଟଙ୍କା ଆଉ 4-5 ଦିନରେ this is also not there. ମୋତେ 11 ଦିନ ଡାକ୍ତରଖାନାରେ ରଖି 4 ତାରିଖ ଦିନ discharge କଲେ. It is not correct.
Yes, madam.
ସେଇଦିନ ଡାକ୍ତର ବାବୁ ଅର୍ଥାৎ 4 ଦିନ ଡିମାଣ୍ଡ ଅଛି. ସେଇଦିନ ଡାକ୍ତର ବାବୁ ବଳକା 400 ଟଙ୍କା ଦେଲେ. This is also not there. ଡାକ୍ତର ସାର୍ଟିଫିକେଟ ଥାନାକୁ ପଠେଇବି ନାହିଁ କିମ୍ବା ତୋର ଦେହ ପୁରା ଠିକ ନ ହେବା ପର୍ଯ୍ୟନ୍ତ ଚିକିତ୍ସା କରିବି ନାହିଁ. This is also not correct because he has already been
Discharged on 28.
ମୁଁ ଏତେ ପଇସା ଦେଇପାରିବିନି ବୋଲି କହିବାରୁ ଅତି କମରେ 300 ଟଙ୍କା 14/9 ଦେବାକୁ ଦାବି କଲେ. ଆଚ୍ଛା, now you come to the evidence.
Yes, sir.
I was being treated by the doctor accused. Read that evidence.
Yes, sir. The accused doctor after my treatment was over told me to pay 300 rupees to issue a medical certificate in my favor. The accused told me that he will issue a good medical certificate. I did not pay any money to the doctor accused. I told the said fact to vigilance inspector. Being told by vigilance babu, I got a written report.
FIR story is that 100 rupees he has already paid.
Yes.
But here says that no payment has been made. I did not pay
any money to the accused doctor.
To any. Okay. Next, all right. I have signed the written report. This is the written report. Okay.
Marked as Exhibit 8.
Okay. Next page.
Yes, sir. The scribe wrote the written report as per my saying. He did not read over the written report to me after his scribe the written report, Exhibit 8. Being told by the vigilance inspector, I reported before the inspector vigilance 3 days after lodging the report. 3 days after lodging the FIR, I went to the office of the inspector vigilance, Navarangpur. After reaching the office, I found number of witnesses.
This FIR
yes, sir.
has been lodged when? That was
15/9/1998.
15/9/98.
15/9/1998.
Right. What is the date of trap?
Date of trap is 14/9/1998.
How?
No, madam. At page 39, at the bottom it says 6:30 p.m. 13/9/98.
After the report is given, preparation starts. So, receive the written report. The report reveals a court case, so and so. Okay. Accused Flora, so and so is treated accordingly. All right. 14th FIR registered ହେଇଛି, that is at page number 36.
Yes, sir.
In the top, it is dated. Then it was written on 13, right? But presented on 14. Then what is the date of trap?
14/9, my lords.
Okay.
Same day.
No, it can't be on 14th. It can't be. It may be on 15th, cannot be. Who is the TLO?
TLO is page 64, PW6. On 14/9, my lords. He also says that.
Okay, just a minute. Oh, there was 2 direction in that FIR. Okay, you are right then. So 14th is the date of trap, right?
Yes, sir. 14/9/98.
Just a minute. FIR written on 13/9/1998. That man who has written the FIR is one Shiva Prasad Achari. Has he been examined?
No, ma'am.
No, ma'am.
So scribe not examined. Then presented on 14/9/1998. Okay.
Yes,
Yes,
ma'am.
Your Lordship.
And date of draft also 14/9.
Same.
14, yes.
Same.
Okay. Now you come to the evidence which you are reading, page
Yes.
number 61.
61. My lord, then he says, he did not read over the written report to me after his scribe, the written report Exhibit 8. Being told by the vigilance inspector, I reported before the vigilance inspector vigilance 3 days after lodging the report.
Now, first of all, this particular line, he did not
Read over
the written report to me after he scribed. This is not a correct statement because it is lekha hoichi page 39 ne ପ୍ରାର୍ଥୀ କହିବା ଅନୁସାରେ
Again.
ଦରଖାସ୍ତ ଲେଖିଲି,
ଆଜ୍ଞା।
ପଢି ଶୁଣେଇବାରେ ଠିକ ଥିବା ଜାଣି ଦସ୍ତଖତ କଲି। ତା ଦସ୍ତଖତ ରହିଛି, ଡେଟ୍ ବି ପଡିଛି। ତେଣୁ ଡେଲିବରେଟଲି ଆପଣ ଶିବ ପ୍ରସାଦ ଆଚାର୍ଯ୍ୟକୁ ଏକ୍ସାମିନ କଲେନି। ସିଏ ଆସିଥିଲେ କହିଥାନ୍ତା କଣ ଯେ ମତେ ସିଏ ଯୋଉ ଅନୁଯାୟୀ କହିଲା ମୁଁ ସେ ଅନୁଯାୟୀ ଲେଖିଲି, ତାପରେ ତାକୁ ପଢି ଶୁଣେଇଲି, ତାପରେ ସିଏ ଦସ୍ତଖତ କଲା। କାହିଁକି ଆପଣ ଏଇଟା କଲେ ନା ଯେହେତୁ ତାର ଯୋଉ narration in the FIR is contrary to the statement which is made in court. That is the reason you did two things. You said through this witness that it was not read over to me, number one. Number two, you withheld the scribe from the scribe must be a charge sheet witness. Let us see that whether he is a charge sheet witness or not. Shiva Prasad Achari. No, he is not a charge sheet, even charge sheet witness to karna thi. Okay. Scribe Shiva Prasad Achari is not a witness to the charge sheet. Nor examined in the trial court. Statement of PW5 that the written report was not read over to him after the scribe prepared the report. In view of endorsement made in the written report. Okay, read it off.
Being told by the vigilance inspector, I reported before the inspector vigilance 3 days from lodging the report. 3 days after lodging of the FIR, I went to the office of the Inspector Vigilance, Nabarangpur. After reaching the office, I found number of witnesses were present in the office.
Just a minute. Underline 3 days after lodging. Statement made by PW5 that 3 days after lodging of FIR, the reparation or trap was made is not correct. It was made on the very day. That trap preparation was made on the very day the FIR was registered.
Yes.
FIR was registered on 14.
14.
14 is the date of preparation, and that is also the date of trap.
Yes.
Made is not correct. It was made on the date of lodging of a FIR, which is also the date of trap. Okay, read it out then.
Yes, sir. After reaching the office, I found number of witnesses were present in the office. On being told by Vigilance Inspector, I caused production of 6 numbers of 50 rupee denomination notes before the inspector and other witnesses. After I handed over money, the vigilance officer took away the notes which I handed over to him and told me that he will issue a certificate that I was assaulted at village Uppargudi. After
just a minute.
Yes, sir.
After I handed over the money, the vigilance officer took away that note which I handed over to him and told me that he will issue a certificate that I was assaulted at village so-and-so. Okay, read it out then.
After receiving money, the vigilance inspector did something in a room and then handed over the notes to me. Thereafter, myself and my brother Tumbeswara went to Khatiguda hospital, and after reaching Khatiguda hospital, and I put the said notes on the table of the accused doctor. I kept the money as per the instruction of the accused doctor.
Wait. So that means he has not stated about any preparation.
No, sir.
Okay. PW5 not
He has
stated
reiterated it in his cross-exam
about preparation for draft. Okay. Then he says that it was after receiving the money, this one, the vigilance inspector did something in a room and then handed over the notes to it. Thereafter, myself and my brother Tumbeswar.
It's the same person, my lord, who was part of that age determination.
Went to Khatiguda hospital, and after reaching Khatiguda hospital, I put the said notes on the table of the accused doctor.
I kept the money as per the instruction of the accused doctor.
I kept the money as per the instruction of the accused doctor.
He is the demand partner.
Okay, read it out then. Paragraph 3.
Thereafter, some officers came and asked the accused if he has received the money from the complainant or not. At this, the accused doctor told to the vigilance inspector he received money from me to issue a medical certificate. Thereafter, the vigilance inspector seized the aforesaid note from the table of the accused and went on typing papers. I have signed the said type paper. Being told by the vigilance inspector, I signed on another type paper which was prepared in the vigilance office and signed thereon. In the vigilance office. This is my signature marked as exhibit. This. My lord.
He has been declared hostile.
Yes, your
Yes,
lordship.
Okay. Read it out, paragraph 4 onwards.
I was examined by the vigilance officer. It is a fact that I told the vigilance officer that accused was asking me a bribe of 300. It is not a fact that I have stated before the IO that the vigilance inspector gave demonstration of chemical test in any manner. No time the IO gave demonstration of any chemical test in my presence.
Okay, no demonstration, any presence. Okay, then.
It is a fact that I explained before the vigilance inspector and the witnesses, those who were present, that the accused demanded bribe to give medical certificate. It is not a fact that in my presence and in presence of other witnesses, the vigilance inspector administered some chemical powder on the notes, which I caused production before him. It is not a fact that I have stated before the IO that one accompanying witness accompanied me to overhear my conversation with the accused and to give signal soon after receipt of the bribe money. It is not a fact that the IO tested and tainted GC notes in the hospital and found that the color of solutions changed to pink rose color. It is not a fact that being tutored by the accused and totally gained over by him, I am deposing falsely. Cross-examination. It is a fact that I got written in my written report that the accused demanded 500 rupees for my medical treatment. The doctor did not charge me any money for my treatment, and though I did not pay money...
Just a minute.
Yes.
It's a fact that the doctor did not charge me any money
Yes,
for my treatment. And though
I did not pay money, he treated me and discharged
me from the hospital. Okay.
And the first line is also important as far as demand for is concerned. The first line, my lords. It is a fact that I got written in my written report that the accused demanded rupees 500.
No, it's all right. He has mentioned that it is, but what he states thereafter is important.
Yes.
He says that the doctor has not charged any money.
That is the
for
reason
my
he has
treatment.
been declared hostile also. That is it.
It's all right. Declare hostile means it cannot be washed up altogether. Whatever you want to get support from it, you can do it. And the accused can also. So the positive statement that has been made that the doctor did not charge me any money for my treatment, and though I did not pay money and treated me, and I did not pay money. He treated me and discharged me from the hospital. In spite of that, I have mentioned in the written report that the accused demanded 500 for my medical treatment.
This is the prior demand.
Right. Then, in my presence...
my presence, the vigilance inspector has not made any chemical test, either in his office or in the hospital. It is not a fact that I forcibly kept rupees 300 on the table of the doctor without the knowledge of the accused doctor. It is not a fact that being influenced by the vigilance inspector, I have given false evidence.
Okay, who has the overhearing witness?
Yes, your lordship. PW3, your lordship.
PW3, my lords. K. Prasad Rao.
At page 54, your
page
lordship.
54.
Just.
K. Prasad Rao.
Just. So, Mr. Rizvi,
My lords.
this paragraph 10,
Yes.
your decoy,
Yes.
who is one of your star witness,
My lords.
not only he has not supported the prosecution case, but he has made a categorical statement
The doctor has not
that
accepted.
doctor means this accused did not charge me any money
Yes.
for my treatment, and I did not pay him money. He treated me and discharged me from the hospital.
Yes.
So he is the only witness to the demand part.
Yes.
So in view of this statement, if that part goes, that
Yes.
means demand part goes,
My lords.
then even if you prove the other part, let us say that
Acceptance.
the amount was recovered from the table,
Yes. Underneath the table
under the calendar,
frame.
and even let us say here he has not accepted, but as per the instruction, let us say that is also a kind of acceptance.
Yes.
Acceptance doesn't mean that I should take it and keep it in my pocket.
Yes.
Okay, if on my instruction somebody
accepts.
keeps it in my bag or in my almirah, so that will also term as acceptance.
Yes.
So here your case, that acceptance, let us say acceptance and recovery, let us say recovery also made. So unless three things have been proved,
Demand, acceptance,
so
and
who
recovery.
is that witness from whom you can find the demand aspect?
Yes.
The only other witness which remains with you is your overhearing
witness.
Is PW?
3, my lord.
Three,
At
my
page
Let us
54.
come to that.
Yes, your lord.
My lords, in this juncture, my lords, may I just place one judgment I am relying, where it says that demand is not required to be proved when there is voluntary and conscious acceptance of money. Your lordship may kindly have a look at this.
No, I have gone through that decision.
Well, this B. Noha versus State of Kerala, my lords, 2006 Supreme Court.
PW3 is the overhearing witness.
Yes, my lords. K. Prasad Rao, he happens to be the senior clerk in the office of Sub-Collector, Navaranpur.
Okay, give that reference, Joe.
Well, page 54.
No,
It's reported in 2006 12 SCC.
2006
12 SCC.
Yes.
277. B. Noha.
D.
B for Bombay. B. Dot Noha, Noha, versus State of Kerala and another.
Well, I am
para 10 and 11. Page 280, para 10 and 11.
Para 10 and 11.
This has been authored by
page
280, my lords. 280. My lords, I have an extra copy for my lordship's convenience.
Pass on. अरे सिर्फ नहीं ऐसे दिल नहीं आओ बात करिए तो
on this aspect, I am relying on 2022 judgment.
Okay, I'll see that just. Which paragraph you said?
That's page 280, para 10.
Read it out.
Man, the evidence shows that when PW1 told the accused that he had brought the money as directed by the accused asked PW1 to take a cut and give the same to him. When it is proved that there was voluntary and conscious acceptance of the money, there is no further burden cast on the prosecution to prove by direct evidence the demand or motive. It has only to be deducted from the facts and circumstances obtained in the particular case. Well, here, if we accept,
read it out.
It was held by this court in Madhukar Bhaskar Rao Joshi versus State of Maharashtra. The premise to be established on the facts for drawing the presumption is that there was payment or acceptance of gratification. Once the said premise is established, the inference to be drawn is that the said gratification was accepted as motive or reward for doing or forbearing to do any official act. So the word gratification need not be stretched to mean reward, because reward is the outcome of the presumption which the court has to draw on the factual premise that there was payment of gratification. This will again be fortified by looking at the collocation of two expressions adjacent to each other like gratification or any valuable thing. If acceptance of any valuable thing can help to draw the presumption that it was accepted as motive or reward for doing or foregoing to do an official act, the word gratification must be treated in the context to mean any payment for giving satisfaction to the public servant who received it. This decision was followed by this court in M. Narsingh Rao versus State of Andhra Pradesh. There is no case of the accused that the said amount was received by him as the amount which he was legally entitled to receive or collect from PW1. It was held in the decision in State of Andhra Pradesh versus Komaraju Gopala Krishnamurthy that when an amount is found to have been passed to the public servant, and this is important, when an amount is found to have been passed to the public servant, the burden is on public servant to establish that it was not by way of illegal gratification. That burden was not discharged by the accused.
So the word that has been used, that voluntary and conscious acceptance of money.
Yes.
In that case, PW1, that means maybe that decoy perhaps, told the accused that he had brought the money.
Yes.
As directed.
Yes. PW5
the accused asked PW1 to take a court and give the same to him. In this case, let us again go to that PW5.
Yes.
PW5 there.
Page 16.
60, man.
In the chief examination, what he has stated,
that
thereafter myself and my brother went to Khattigura hospital. After reaching Khattigura hospital, I put the said notes on the table of the accused doctor. That particular sentence which is there, according to you, this satisfies that observation, that voluntarily and consciously accepted.
Yes.
Because he says that I kept the money as per the instruction of the accused doctor. Okay. Now, Right. Now we come to that overhearing witness is PW3.
Yes, sir.
Yes, ma'am. Page
Page
54.
54.
Yes.
Your Lordship has it, ma'am?
Yes.
On 14/9, they also reiterate, my Lord, on 14/9 was the trap preparation. On 14/9/98, I was working as the senior clerk of the office of Sub-Collector Navarangpur. On that day, I had been to the Vigilance Office, Navarangpur. I attended the Vigilance Office as per the requisition placed by the Vigilance Office. After reaching Vigilance Office, the Vigilance Officer introduced me to the complainant. Complainant told me that the doctor of Khatiguda was demanding bribe of rupees 500 to issue a medical certificate. The complainant further told me that he has already paid rupees 100 and he will pay him further sum of rupees 300.
This part there is no corroboration from PW5.
No.
Okay.
But as far as the other witnesses are concerned, my lords, like 2, 4, and 6.
Official witnesses,
Yes,
they have
official.
stated.
They are
All right.
reiterating whatever.
Because they assume overwhelming support from this.
Okay.
They have corroboration.
Yes. Then complainant produced 6 numbers of that he has stated.
Yes, ma'am. The witnesses noted down the note numbers and put their initials on the said notes. Thereafter, the vigilance officer gave demonstration of chemical test by preparing chemical solutions in 2 separate glasses.
You come to the paragraph number 2.
Yes, Your Lordship. After aforesaid instructions were given, we all proceeded to Khatiguda. Myself and the complainant went to Khatiguda hospital. After reaching Khatiguda, we found the accused doctor was sitting in his chamber. And seeing the accused, the complainant kept the aforesaid tainted GC notes on the table of the accused and came and told me that he kept the money on the table of the accused.
Just
Admittedly, this overhearing witness have not heard any conversation.
He's not even in the room.
That is the reason he is not able to hear any conversation. That's quite obvious.
So, that means though PW5 says that as per the instruction of the accused doctor, he kept the money on the table. That is not supported by the overhearing witness.
Yes, Your Lordship.
Well, it's there, my lords.
We'll hear it.
It's there.
Huh?
He supports, my lord. It's there.
Where?
Yes.
Read it again, that line.
He doesn't support, my lord. I don't understand.
Para 2.
After reaching Khatiguda, we found the accused doctor. Para 2 of PW.
3. Read PW3's evidence.
Yes, Your Lordship.
The overhearing witness.
Yes, my lord.
As I read from the evidence of PW3,
yes,
I find that what statement PW5 has made,
yes,
that as per the instruction of the accused, I kept
no, that
money.
part is not. That part is not. He only fortifies that the money was found below a calendar from the table.
We are not going to that first.
No. That has not been corroborated.
5 statement that as per instruction of the appellant, he kept the money on the table of the appellant is not supported by PW3. PW3 stated that seeing the accused, seeing the appellant, in his chamber, sitting, comma, PW5 kept the GC notes
on the table
of the appellant and came and told that he kept the money on the table. So, read it out, continue. At this,
I gave the pre-arranged signal, and getting my signal, other witnesses and vigilance officers rushed to the spot. After reaching the spot, the vigilance officers caught hold of the hands of the accused and recovered the tainted GC notes from the table of the accused. The money was found below a calendar. The vigilance officer seized the notes. Thereafter, the notes number were tallied by the witnesses. Thereafter, the vigilance officer seized one calendar and the aforesaid tainted.
No, another thing, Mr. Rijby, if these two statements also taken into account, let us say PW5's statement is that accused instructed,
And
for which
he kept the money on
PW5 kept the note on the
Table.
table, that means on the that calendar, below the calendar. That he also came and told that I have kept the money. So if that is the situation, so obviously the accused has not touched the money. So how his his hand wash also did not change any color.
This chemical examination report has given a
No,
positive.
question is that how it will change the color unless he has the occasion to touch the money,
Yes.
to handle the money. The question of changing of color doesn't arise.
In my humble submission, he has accepted the money in his own hand. That is the
Who has stated that?
Nobody has stated, man.
Then
The C report says
no, C report is not. We are to convict a person and he must have lost his service. You are to find clinching evidence against the person. Three things are required to be proved.
Yes.
And all the three things, even this decision which you say, thereafter hundreds and hundred decision says that unless all those three are proved,
demand, acceptance, and
that cannot be. And here totally lacking, that demand part is totally lacking. This acceptance part, one witness says that he went and he was sitting in the chair, he kept the money and came to me and told that I have kept the money on the table. Table means below that calendar.
Calendar frame. Yes.
So that means maybe that he was not aware, the accused was not aware that he had kept the money. Then the as per instruction, that very statement is missing in the evidence, in the statement of PW3.
Yes.
Okay, you continue.
Yeah. The money was found below a calendar. The vigilance officer seized the notes. Thereafter, the notes number were tallied by the witnesses. Thereafter, the vigilance officer seized one calendar and the aforesaid tainted GC notes and prepared the seizure list. The vigilance officer also seized the paper chits containing note numbers of the aforesaid notes and prepared the seizure list, marked as Exhibit 7. This is my signature on Exhibit 7, marked as 7-1. Thereafter, the vigilance officer prepared a detection report. Exhibit 6 is the detection report. This is my signature on Exhibit 6, marked as Exhibit 6/2.
Where this witness has stated that the hand wash of the accused was taken, this particular witness.
In the cross-examination, there is a...
No, in the chief examination,
No.
I didn't find that in the chief examination that money was found below a calendar, he has said.
Yes.
That was seized by vigilance officer, he has stated.
And then there was tallied, he has said.
Then it tallying, but where is that material that hand wash was taken and that changed the color or did not change the color. That statement is not there in the
statement is not
chief
there.
is not.
No,
Acha.
and
Let us see now the
only observation is there that after reaching the spot, the vigilant officer caught hold of the hands of the accused and
Right.
recovered. That's it.
So now come to the cross examination.
My lord, para 3. The complainant along with his brother entered inside the room of the accused and I remained outside the room. I cannot say any.
That brother has been examined.
No, my lord.
No.
Okay.
That same brother, my lord, who we have alleged.
Just.
Tumbeswar.
PW5's brother accompanied him.
Brother's name is Tumbeswar Nayak.
Whose name is
Tumeshwar Nayak.
Tumeshwar Nayak and was present
Along with
on the date of trap in the office of accused, not examined.
not
No,
examined.
not examined.
Okay.
Now, my
Now
lord,
read it out.
yes, I cannot say anything in what manner the money transaction relating to the aforesaid tainted GC notes happened in the room of the accused,
Okay. That
as
is the
I
reason
was
why.
present outside the room. Yes,
So this is a very positive statement he has made.
yes, my lord.
That I was present in the outside.
Yes.
तामने खाली सीए
Accused
देखिला नहीं सी जाटा देखिला
Again.
सेटा हुची the complainant went
Yes.
and kept the money on the table.
My lord, if I may say so, my lord, that also he has not said.
No, yes. Seeing the accused, the complainant kept the aforesaid tainted note on the table
and came and
told me.
So, my lord, my humble submission is, once he says he has said he has come and told me, he is not saying I saw this. He is saying he has come and told me that he kept the money on the table.
No. That part, after reaching this answer, found the doctor, so we all proceeded to myself, went to the hospital. After reaching, so we found the accused. We found
Yes, my lord, we found the accused.
We found that man, ଆମେ ଦି ଜଣ ଯାକ ଦେଖିଲୁ ସେ ବସିଥିଲେ ଚାମ୍ବର ରେ ତାପରେ ତାକୁ ଦେଖିନି complainant kept the money on the GC notes on the table ତାପରେ ସେ ମତେ ଆସି କହିଲା ଯେ ସେ ରଖିଦେଇ ଆସିଲା. It's all right. So he has seen
came and told the overhearing witness.
That part he has seen, that about the keeping of the GC. In fact, that is also not disputed.
Yes,
you are also
found. Yes.
that part has been put in the 313 statement also.
And we have
you said that yes, it was recovered from the. So there is no dispute. Okay.
I bought him.
Okay. Thereafter, read that.
Yes. I cannot say anything in what manner the money transaction relating to the aforesaid tainted GC notes happened in the room of the accused, as I was present outside the room. When the vigilance officer asked the accused if he has received the money, the accused told that he neither he demanded the money to the complainant, nor the complainant offered money to him.
Okay, then, this is the immediate statement that has been made.
Yes, ma'am. Then, my lord, the hand wash, your lordship was asking, the hand wash of the accused in chemical solution was not taken by the IO after recovery of the tainted GC notes. It is not a fact that the complainant has told nothing before me regarding asking for bribe by the accused in the vigilance office or in any place to me.
So this is a witness. It is your witness, and he has not also been declared hostile.
Yes, sir.
What he says that even the hand wash, neither the decoy nor the overhearing witness have stated that the hand wash of the accused was taken in sodium carbonate solution. And in fact, they have that the money was kept in the table, it was recovered from that place. So where from there was scope or there was an opportunity with the accused to toss the money. So that means it shows that hand wash which was sent to chemical examination, that was not of the accused. It was manipulated because you are required to take the hand wash in presence of the important witnesses like decoy and the overhearing witness. Your witnesses who have not been declared hostile, like PW3, they are saying that no hand wash was taken. So even if the CE report was on which you are making your submission, that shows that the accused has tossed the money, that cannot be accepted because the hand wash was not taken. That was not of the accused. The hand wash which was sent. And other witnesses might have stated about the recovery part.
About hand wash also they have stated.
It's all right, but in view of these discrepancies, how can you? They must have also stated that. Let us say one of such witness who has stated that hand wash was taken. Luigi.
Minute 52. I'll just assist your lordship. PW2.
PW2.
At page 50, if your lordship wants that, he is a junior clerk in the office of ITDA. That's at page 50.
So demonstration part, you leave it.
Yes, madam. I'll just straight come to my lord, page 52, part of paragraph 3. If your lordship wants, yes. I'll place paragraph 3, madam.
Yes, yes, read it out.
Thereafter, myself and other members of the trap party proceeded to Khatiguda in the jeep of the vigilance department. After arrival at Khatiguda, the complainant and the accompanying witness were asked to proceed ahead to the office of the accused. After some time getting pre-arranged signal of the accompanying witness, myself and other members of the trap party rushed to the hospital. After arrival in the office of the accused, vigilance inspector caught hold of the hands of the accused and challenged him to have accepted bribe. But the accused refused to have received the bribe from the complainant. Being asked, the complainant also disclosed that he had kept the tented GC notes on the table of the accused under a medical calendar. Thereafter, the hand wash of the accused was taken with chemical solution, but the color of the solution did not change.
Hand wash was taken, it has been certified by this witness.
No, only this witness, madam. Not by the overhearing witness or the tainted GC notes were then handed over to us for verification with the numbers noted down by us in separate paper sheets, and on verification the number tallied. The tainted GC notes were then seized by the IO on the seizure list in which I have put my signature.
So this refusal of the accused to have accepted the money, accused refusal.
Yes, Your Worship. That is consistent.
When confronted.
Yes, Your Worship.
That has been stated
by everyone.
By first PW3 has stated.
Yes, Your Lordship.
Then PW2 has stated.
Yes, Your Lordship. Then PW6 has also stated, who is the IO.
Acha, PW6 the TLO.
TLO,
yes.
TLO, not the IO.
Yes, I'm sorry.
So TLO has also stated.
Yes, Your Lordship. And so, my lord, at this point, my lord, TLO and PW2.
This conduct is admissible under section 6 of the Evidence Act, res geste.
Yes.
So immediately after, suppose somebody becomes nervous,
yes,
starts shivering,
yes,
so that would show the guilty mind.
Absolutely correct.
But somebody challenges it, I have not accepted any buy, I have not received any, I have not demanded. Immediately after, so that is admissible under section 6 of the
evidence.
So that would show the bona fideness of a person. Yes. Next, read it out.
Yes, ma'am. The tainted GC notes were then handed over to us for verification with the numbers noted down by us in separate paper sheets, and on verification the numbers tallied. The tainted GC notes were then seized by the IO under the seizure list in which I have put my signature. Exhibit 3 is that seizure list, and Exhibit 3/1 is my signature thereon. The medical certificate of the complainant was also seized under a seizure list, marked Exhibit 4, in which Exhibit 4/1 is my signature. Some other official records were also seized on production by the accused under a seizure list marked Exhibit 5. 5/1 is my signature. Regarding such detection, a report was prepared at the hospital in which myself and other witnesses put our signatures. Exhibit 6 is that detection report, and Exhibit 6/1 is the signature thereof. Then, my lord, cross-examination.
Okay, just a minute.
Yes, sir.
Let us say this witness has stated as I find out of 3, that the hand wash of the accused was taken in chemical solution,
Did not.
but the color did not change. He has stated like this.
Yes, Your Lordship.
Yes, ma'am.
So where is the statement that was collected in a bottle
and kept.
and it was sealed in our presence and our signatures were taken, paper seal was made to show that it was collected
At
and
that spur of the moment.
the very thing which was collected
Which did
also
not,
reached the chemical examiner. That path has to be traveled with potent material.
All dots have to be connected.
Right. So unless your witness, he says that simply hand wash was taken, that would not be sufficient.
It should have been asked,
Right. The public prosecutor should also bring that it was collected, it was kept in the bottles, and it was sealed, and the paper slip was attached. His signatures were taken, not only of the accused, but also in whose presence that was collected. So that would have a clinching evidence that yes, there was no question of tampering with this. So if you collect something, hand wash was taken.
Yes.
If that was not sealed at that place, you take it to your vigilance office. Then you can add that powder, phenolphthalein powder. So obviously it would come out. So I do not find anything that the hand wash was collected and sealed and
our
signatures of the.
My lordships are indicating that may have been manipulated.
Right, there is scope of manipulation.
I understand.
Once you do it, like you see, when in NDPS Act cases, suppose a thing is collected, it is weighed at the spot, samples were collected, then samples are required to be sealed.
In presence
that are the place of itself. The seal which is used for sealing, that used not to be kept with him, that person who the person who seized it. It is to be kept with a third person, and he will be asked to produce it in the court, so that the court will verify the seal impression, which is the. Otherwise, if the seal remains with me, and I can tamper it easily.
Can be interpreted.
So that evidence is not there. PW2, though, stated hand wash was taken with chemical solution, but color of solution did not change. He has not made any statement that the hand wash was collected in the bottle and it was sealed and their signatures were taken on paper slip. पेपर सीलटा कौन कि आपणकर गोटे कागज रे जो माने तांकर दस्तखत सब निया जीवो हला जति को अछन सब अक्यूज्ड भी दस्तखत निया जीवो ताकू कोन करा जीवो ना से जो बोतल टारे ताकू गुडेई देबे गुडेई देई किनी ता ऊपर सील जो मुद मारा जीवो जो मुद ऊपर आर पर्सनल सील दिया जीवो पर्सनल सील हैंडओवर करा जीवो थर्ड लोक ताले ये आकु जदि से परे नहीं टैंपर करिया चेष्टा करिवो ए कागज चिरजिवो तेणु एही परी अवस्था रे सेटाकू जिबा दरकार एटा जेतेबेले कोर्ट रे पहुंचीबो कोर्ट भी ताकू वेरीफाई करिवो जे ये सील टैंपरिंग हेइन तो अच्छा से बाबू तमे आनो सील टाकू आनो से देखिबो जे हां ए सील से सील मैच करची ताल जानिबो ये जो जहां स्पॉट रे जबत हेइथिला जो जिंसो मो पाखरे आसी सेही जिंसो पहुंच से विषय रे लिखा हबो ऑर्डर शीट रे दे आर वेरीफाइड दी बॉट सील पटल इट इज इंटैक्ट तापरे जीवो सेठी सेठी समाने कला दिस इज ए लिंक so yes next
then cross examination. It is not a fact that I have not stated before the IO that the complainant disclosed before us that the accused initially demanded rupees 500 and agreed to take rupees 300 as bribe for issuance of an injury certificate, that the accused produced 5 number of 50 rupees GC notes before us, that a compared the numbers of the GC
this
notes.
Statement he has not made which you have suggested that has been proved through the IO. आपण एटी कन्फ्रंट कले तांको प्रीवियस स्टेटमेंट ऑफ कन्फर्म कले ना जे आपण पुलिस पाखरे एक कथा कहि नांती जे कंप्लेनेंट डिस्क्लोज कला आपनको पाखरे जे अक्यूज्ड प्रथमे 500 टंका मागिला तापरे 300 टंका लांच रखिकिनी इंजुरी सर्टिफिकेट दबाकू राजी हैला एई जो जिंस विषय रे आपण पुलिस पाखरे बा तदंतकारी ऑफिसर को पाखरे किछि कहि नांती ए जो कहिले तार प्रीवियस स्टेटमेंट से कहला नाइ मु कहिची सो नाउ इट इज टू बी proved through the investigating officer. Who is that investigating officer?
PW6 Vijay Kumar Jena.
Let us come to that. Let us see that. Say line ta apon pacharjan na nai.
Page 64.
64. 64 it starts about that confrontation part.
Cross examination is page 68.
Cross 68. Tara confrontation kudichi.
Para 10. I can read out the entire thing, but para 10. It is not a fact that the complainant has not disclosed before any person that the accused was demanding bribe and
no, that is not the count. Individual statement कहिबे record करछि था statement किए से जो PW2 रो आपण जो ताको confront कले तार previous statement who has recorded that statement this particular witness this जो PW7 record करछि नहीं PW6 टाइट PW just a minute 6 ना 7
not 6 then it later went to 7 my lord
6 is the TLO 7 is the investigation officer.
Investigating officer nothing has been asked so and so has
nothing material TLO statement is important
except for an injury report my lord nothing
अरे बाबा से जो कन्फ्रंटेशन टा हला जोटा को पचारले आपण 2 नंबर साखी को जे आपण एमती पुलिस पाखरे कहि नांती तदंतकारी ऑफिसर मानक पार कहि नांती सी जदी मानि जाई थांदा हम कहिनी मैटर इज डिफरेंट लिखाई थांदा कोन इट्स ए फैक्ट दैट आई हैव नॉट स्टेटेड बट सी कुछ इट इज नॉट ए फैक्ट ता माने सी आपनकर सजेशन को मना करछि जे नाइ मु हां पुलिस पाखरे कहितली तेनु सेटा प्रमाण हबो काहा द्वारा पुलिस जेतल आस्तान ताको पचार थांदे बाबू देखिलो 2 नंबर साखीर स्टेटमेंट देखो सी आपण पाखरे एमती कहिछि की ता द्वारा सेटा लिखाई थांदा सी पुलिस ऑफिसर कहि थांदा इट्स ए फैक्ट दैट ही हैज स्टेटेड बिफोर मी like that or he has not stated
page 64 page 64 the last 3 lines it starts
just a minute let us 64
deposition of PW6 in the office the complainant you got it ma'am below part in the office the complainant narrated the fact of the FIR to the witnesses and told that the accused demanded a bribe of rupees 500 to complete his treatment. The complainant further told us that the accused was, there's some typographical error, as the doctor first took rupees 200 from him for his treatment and again demanded further sum of rupees 400. The accused was working as the doctor. On 4/9/98.
Leave it. Come to that. That has not been put to. So paragraph 4, it's all right. Accused produced so and so, and I compared the so and so. Okay. Who else has stated about this hand wash further?
IO Malo.
No. The PW1. Who is he?
PW1 Malo is the senior clerk in CDM office.
Okay, leave
Prabhakar
it.
Pandal.
Is not important.
No, ma'am.
Not important.
Aja, ଦୁଇ ଗଲା ଆମେ then
Teen gala.
Teen is the overhearing witness.
3 ଆମେ ପଢିଲୁ then
Yes.
Chari is the
ଚାରିଟା
vigilance
କି
constable.
4ଟା କଣ
No, he is
Vigilance
there
officer.
for the preparation report. He is the witness to the preparation
ଆଚ୍ଛା ଛାଡ
report.
ଦିଅ
That is not
ତାପରେ
important.
Now, my lord, 5
5
is the
ଗଲା
5 is the recall
5,
number.
6, 7. There's nobody else. ma'am.
6 ଟା ପଢନ୍ତୁ
Yes.
Yes, ma'am. So TL 64.
6 ଟା ଅବିକା ପଢୁଥିଲେ ପରା
Yes.
ହଁ
Let's start.
ନା you come to that ସେ ଯୋଉ ଅଫିସ ପାର୍ଟ କୁ ପଳାନ୍ତି ସେ ଇଏ ଗୁଡା ଛାଡି ଦିଅନ୍ତୁ
ଆଜ୍ଞା,
ପ୍ରିପାରେସନ ଛାଡି ଦିଅନ୍ତୁ
Aye.
Then my lord,
My lord, if I come to
page
page
66.
65 at the bottom, if I may start with that.
ହଁ
To accompany the complainant to the spot,
right ହଁ
I appointed an accompanying witness, namely K. Prasad Rao, which is PW
3.
3, my lord.
right
I had instructed him to overhear the conversation between the accused and the complainant and to give signal by combing his hair by means of his hand in the event of receiving bribe money by the accused from the complainant. Then prepared the preparation report, which has already been marked as Exhibit 2. This is my signature on Exhibit 2, marked as Exhibit 2/3. Thereafter, I, along with other witnesses, proceeded to the spot. Before reaching the spot, we, excluding the complainant and the accompanying witness, remained present at a distance of about 70 yards away from the project hospital. The complainant was directed by me to proceed with the accompanying witness to hand over the tainted GC notes to the accused as and when he will make demand. After some time getting signal from the accompanying witness, we all proceeded to the spot. The spot is the room of the accused doctor. After reaching the spot, I myself gave my identification and identification of the witnesses and asked him if he has received the bribe from the complainant. At this, the accused denied to have received the money.
just a minute
Reiteration, madam, as your lordship has noted, madam.
okay yes
Thereafter, being told by me, ASI K. Mohanty prepared chemical solution of sodium carbonate and kept the same in 2 separate glasses. Thereafter, being directed by me, the accused dipped his right hand in 1 glass of solution and another hand in another glass of solution. After doing this test, I ascertained the color of the solution in both the glasses did not change.
yes
I-
just
I preserved the sample of solutions in 2 separate bottles. These are the said bottles marked as MOS 4 and 5. Thereafter, I searched for the tainted GC notes and found the same from under a table calendar which was lying on the table of the accused. This is the said calendar marked as MO6. Thereafter, as per my direction, the calendar was tested in chemical solution, as a result of which the color of solution changed to slightly pink rose. I preserved the sample of solutions in a bottle. This is the said bottle, marked as MO7. Being told by me, the official witnesses compared the note numbers and found tallied with their earlier notings. Thereafter, I seized the note via Exhibit 3. This is my signature on Exhibit 3, marked as Exhibit 3/2. I have also seized the medical certificate issued by the accused in favor of the complainant dated 14/9/1998 and prepared the seizure list, marked as Exhibit 4. This is my signature on Exhibit 4, marked as Exhibit 4/2. I have also seized one injury report and bed head ticket from the case hospital via Exhibit 5. Exhibit 5/2 is my signature. This is the injury report marked as Exhibit 10. Thereafter, I prepared this detection report, which has been marked as Exhibit 6, and this is my signature as Exhibit 6, marked as this. I preserved all the sample bottles and sent the same for chemical analysis.
Even this your TLO, Mr.
Lords.
Rizvi,
My lords.
your TLO, what statement he has made about the sample bottles? First, he said that hand wash was taken
Yes. It did
and
not change color.
it was preserved. Then again, this line, that was no change in the color. I preserved the sample bottle. Has he made any statement that that was sealed?
No, that statement has not been.
And whose seal was used? That is not there.
Not
So that means there is no
authentic.
no evidence that at the spot the hand wash, if any, collected from the accused, that was sealed
and preserved
properly, and then it
Sent
was
to
taken to the court for forwarding it to the. So
Yes.
that if that evidence is lacking, then how even if those two sample button, some traces of that powder was found, phenolphthalein powder was found, that would not be helpful. You must adduce that evidence. This totally silent that the sample bottles were simply stated, I preserved. That is not entire thing.
He should have
So right, he has to say that it was sealed at this fall. These are the paper seal or whatever. Maybe my seal was used or whatever.
He should have described everything.
Yes,
The
yes.
entire procedure.
Obviously.
I understand.
So even PW6 simply stated that he preserved the sample of solution of hand wash of the appellant in bottles. Bottles kelo na bottle kelo?
Separate bottles.
Separate bottles.
Separate bottles.
In separate bottles.
Two right hand and left.
In two
Separate
separate
bottles.
Okay. Separate bottles.
Marked as MOs. Here it is written
MO
4 and 5, but it's
MO
actually 3 and 4.
And MO 5. 4 and MO 5.
But it's actually MOs, it will be 3 and 4 because that
Achha,
time I was,
yes. All right, MO3,
is it
MO3 and MO4.
3 and 4? No?
In the chemical report,
Yes.
it says 3 and 4,
Yes.
as your lordship saw.
Not stated that these MOs were sealed at the spot. Similarly, I would MO5 na?
Yes, it was 3 and 4.
No,
Only
3 and 4.
Calendar 5.
Calendar
is 5.
Calendar 5.
Calendar was.
No, sorry, 7, my lord. Sorry.
Huh?
7.
Ticket.
Emana it actually 7. Calendar frame ta list of exhibit 5 लिखा है.
Judgment पछपटे देखो.
Again.
Judgment पछपटे है क्या?
Calendar.
MO6.
MO6 टा होची calendar. Calendar was टा मुको होची. एटा बोले MO7 हवो बोले.
My lord,
If your lordship may kindly come to page 77, my lord, that report, chemical examiner's report.
एटा होची 7 होची calendar was.
हाँ, my lord, तांको examination ने लिखा है 7. किंतु your lordship saw the list of exhibit of for C report. सही तरह से टिके exhibit number report support है. Page 75 है.
Right.
And it's up to exhibit 5 only. There is no further
6, 7 नहीं.
6, 7 से किसी लिखा ही नहीं.
Okay, so no, what the thing is that even this gentleman PW6 your TLO has also not stated about the sealing of the.
Yes.
Okay, now read it out. Yes. Then.
I preserved all the sample bottles and sent the same for chemical analyst for chemical examination. This is the report of chemical analyst marked as exhibit 11.
Now this was done when? This on 14th itself?
Yes, sir.
Right?
Yes.
So 14/9/1998 trap date
and detection
detection
yes
and the collection of
material objects
samples.
Sample bottles.
Okay, sample bottles mean material objects.
Yes.
MO. When that was produced in court?
My lord, that was produced on, my lord, 16/9. Page 74, my lord, is the forwarding report.
Just forwarding report ta maga dekhe.
Again, 74 re ache.
Right. पेपर उठा खोलो.
My lord, chale?
नहीं ठीक है. 74.
Yes, ma'am. Forwarding report.
Forwarding report chemical अच्छा.
Chemical examination exhibit. That is what your lordship was asking.
In
the middle, my lord, but the color did not change.
ঠিক আছে এটা ডেটটা কেতে ଅଛି?
My lord, তা পর পেজ যদি ଯିବେ my lord, ତା ତଳେ ସାଇନ୍ ହେଇଛି 16/9.
16/9/98.
16/9/98.
14/9 ରେ ହେଲା.
And thereafter, my lord, there is the office copy has been sent on 17/9.
16/9/98. produced in court
1 day after the
for forwarding
2 days.
to SFSL, right?
Yes, ma'am. It is my RFSL, Regional Forensic Science Lab.
Page 76 it also.
Specimen seal used in so-and-so exhibits in presence of so-and-so, in whose custody. You see that page 75.
At the bottom.
Page 75.
Yes, ma'am.
In the description of exhibits,
Yes.
you'll find that entire thing, it is mentioned as sealed.
Yes.
So that means it was not sealed at the spot. It was sealed subsequently at the office. 1 day thereafter, it was produced in court.
Your Lordships are absolutely correct. But if your Lordship may see, that seal bottles have all these things have happened on 14/9 during the detection only, my lord. Your Lordship are pointing out page 75.
No. Nobody has stated, including the TLO,
Yes.
that the samples which were collected by the, let us say, hand wash
Yes.
and the calendar wash,
Yes.
that was kept in any bottle. First of all, it was kept in the bottle and it was sealed, right?
Yes.
So that part has been done at the spot on 14th. When it comes to the court on 16th, the court finds that it was a sealed bottle. So that means whatever has been done, that means the sealing thing must have been done afterwards, after they left the spot, came to the office, where 2 days were taken to forward these materials. So there the seal was done.
In fact, my lord, if your Lordship may kindly come to page 75, where the remarks that it has been written on the third line. On 14/9/98, at the time of preparation, hand wash of official witness. Then there is the third column. 1 seal bottle containing solution on 14/9/98 at the time of detection of the trap case. The wash of fingers of right hand of the accused, it was sealed then and there.
No. This question is not seizure of. We are not disputing your seizure.
Sealing, my lord.
Sealing is important.
And preservation. And preservation.
You have the seizure list indicates it is dated 14/9/98. Yes. So to that effect also number of witnesses have stated. Question is when you have sealed it, because every witness has stated that the hand wash does not change the color. But when it comes to the court, it is found that not only it is sealed, but also the C report indicates that it has changed the color. Even the oral evidence that the accused has not touched the money. There was no necessity to even suppose, let us say, that C report could not have shown any traces of sodium. And this evidence would have been laid in the clinching manner that accused has demanded. And he, on that day he came and he asked him to keep that money. At that point of time also the seizure was made. So it would be seen that it was not only accepted, but demand was there, acceptance was there, and recovery was there. All three things would have been, even without any hand wash changing the color.
Other circumstances.
Right. It is need not that in every case my hand wash should be. If I do not touch the money.
Yes.
Or if I instruct Mr. X to collect the money.
On my behalf.
On my behalf.
Yes.
So the question is that it is just a perhaps that investigating officer or TLO thought that unless if this is done, then our case may fail. So that is how this tampering has been made in the office. Seal has been made.
He was over.
Even if it would not have been there, it would not have been there in the C report,
Yes.
but other things are there.
Others are
Your complainant, your overhearing witness, their evidence would have appeared.
Suffice.
Yeah. So that would have sufficed, right?
Yeah.
So, these are the lacunas which are. So what about the any other witness?
My lord, if I may say, at page 75, at the very bottom, your lordship read, my lord, the specimen seal used in sealing the bottles marked as exhibit 1 to 5 is affixed below in presence of Sri Balaram Patra, OIC election. My lord, he is not a witness. As it appears, he might have been part of the trap my lord, party, but he is not a witness at all.
The specimen seal used, just a minute, the specimen seal used in sealing the bottles, read it once again.
My lord, the specimen seal used in sealing the bottles, because this is the court which is marking this.
No. The specimen seal used in sealing the bottles marked exhibits 1 to 5
is affirmed below.
Is affixed below. Affixed below na se jo kala rangta diya hai.
Yes, ma'am. Affixed below.
In presence of
Sri Balaram Patra, OAS OIC election section, collectorate Nabarangpur, executive magistrate, in whose custody the seal has been kept.
The lordship are talking about that procedure.
Right. That witness has not
been
there.
That is that.
So, Mr. Rizvi, another thing.
This might have happened in the vigilance office.
So, Balaram Patra's presence, everything has been done. Sealing has been done.
But not
Balaram Patra had not gone to the spot.
Exactly.
So, obviously, it has been done in the office, vigilance office.
In the vigilance office.
Even if that, suppose the seal is not produced in court, that brass seal, but brass seal impression which is given, that is produced and it is compared, that will also suffice, right? Here, when this particular seal was produced, it is a specimen seal, but that seal should be prominent, not in this way, this black. How can you see it? There must be specific that
nothing is visible.
A seal must be prominent one, so that the court can verify, yes, this seal which is there is also there in the
it's similar.
It should be identifiable.
Right. Now this is the evidence of PW6.
PW6.
Now we come to the last witness.
Yes, sir.
IO, page 70.
Please read it out.
Just even IO PW6 has also stated that the accompanying witness was outside the room in his cross examination.
Read it.
Yes, on page 68. If I may say so,
read from paragraph 6.
Yes, sir. No time prior to the date of trap I had been to the spot. It is not a fact that the table which I say does not belong to the accused, and that no chair of the room was in possession of the accused, or the accused was sitting on the chair from the room where I entered. The room from where I seized the calendar is accessible to others. This is also important. 8. At the time when the complainant entered the room of the accused, the accompanying witness was present outside the room of the accused. I recovered the tainted GC notes at the instant of the complainant. On being asked by me, the accused told me that he cannot say how the money was found inside the table calendar. It is not a fact that after sealing the sample bottles, I kept the seal with me. It is not a fact that the complainant does not disclose before any person that the accused was demanding bribe and he received a part amount. It is not a fact that producing some concordant documents, I am deposing falsely. Now, my lord, I'm only relying on para 8, where he says at the time when the complainant entered inside the room of the accused, the accompanying witness was present outside the room of the accused. It corroborates the statement given by my lord PW3, who also says that I was outside the room.
Okay, now you come to the last witness.
Yes, sir. Page 69.
Yes, no. The relevant part must have sanction order ta paila se acha.
Yes, my lord. Only that is what he
arrested the accused. Samples were sent for C examination. Okay. Accused was released on bail then and there at the spot, or he was forwarded to court. नहीं सर संगे संग बेल ही है okay आगे से दे दो बेल spot yes.
And then in cross examination he says, as per the complaint, the accused had been demanding rupees 400 as bribe for sending the injury report to the PS. ASI PC Nayak had stated before me that he had received the injury report on 24/8/1998, but he had registered the case on 14/9/98.
No, injury report ta pura देखौची केबे पाइला तार डेट टा
discharge जोटा बे देखिले सर
28 discharge was 28
14 no
नहीं आपण कहले 24/8 किंतु आपण कहउछन सेटा सर इंजुरी रिपोर्ट नो सेटा सर रिक्विजिशन टा
नहीं जो बेडेड टिकट टा
हां बेडेड टिकट टा 24 रो 28
date of discharge in that bedhead ticket was 28/8/1998
right
but my lord what he is saying is the injury report what is to be given by the doctor to the police station was given by the doctor on 14/8. ASI PC Naik has told him.
What you mean to say in this way that if the he has been discharged from the
hospital on 28
hospital on
28/8/98
28/8/1998 रे
ଆଜ୍ଞା
ସେ ଯଦି discharge ହେଇଗଲାଣି ଏବଂ ସେ ରିପୋର୍ଟ ଟା ଯଦି 24/8/98 ରେ ତା ପାଖରେ ପହଞ୍ଚି ଗଲାଣି ସେ ତେଣୁ ଏଇ ଯୋଉ ଡିମାଣ୍ଡ କରିଲା ବେଳକୁ ଆଉ କିଛି ନଥିଲା there was no scope for no work was pending with the appellant to make a demand because he has already fulfilled whatever is required to be done he has done as per the complainant the accused had been demanding so and so for bribe
there is a confusion between this injury report and medical certificate all through in some places it has been written injury report some places it is regarding medical certificate
Melody, if I may say,
ये जो statement टा कहिला से ASI PC Naik had stated before me that he had received the injury report on 24/8/1998 तो एई गोटाको पूरा आपण केस ही होउची जे इंजुरी रिपोर्ट टा पठेइबा पई
आगे
से टंका डिमांड करथला
इंजुरी
आ
रिपोर्ट
से
ट्रीटमेंट पे
हां से जा भी हो ट्रीटमेंट तो ओवर ही जाइची
ट्रीटमेंट
ऑलरेडी
ओवर ही जाइए इंजुरी रिपोर्ट
इंजुरी रिपोर्ट टा पठाई जाइची 24/8/1998 को
ଆଜ୍ଞା।
तेणु आउ से जो
nothing
24/8 रे जो दिन सी ये हैला माने सर एडमिट हैला जो दिन एडमिट हैला सेही दिन ही इंजुरी रिपोर्ट पळेइची ताले सर दैट इज माय
4/9 रे डिमांड कथा से कहूची
आज्ञा
ଆଜ୍ଞା।
तो डिमांड सर किछि स्कोप ही नाही अबाउट
डेट ऑफ डिमांड टा होची 4/9 तो हां डिस्चार्ज
discharge is 28/8/98
नहीं
नहीं
trap is 14/9/90
नहीं I about
Date
your
of
lordship was saying on 4/9 while he was that is his statement that while he was being discharged he was asked you pay the rest of the amount
आउथरे पेज 38 को पळे आसुन
Right.
जोटा एफआईआर देइची
नहीं
पेज 38 डाक्तरखाना रे रही
आज्ञा
4/9/1998 शुक्रवार दिन डाक्तरखाना रु डिस्चार्ज कले
आज्ञा
सेही दिन
आज्ञा
सेही दिन माने 4/9/98 दिन
प्रहराज
डाक्तर प्रहराज बाबू मते बळका 400 टंका न देले डाक्टरी सर्टिफिकेट पठाइबी नाही
My lords, to the specific query regarding this medical certificate and injury report vis-a-vis, Lordship may kindly come to the deposition of PW6, page 67. PW6, my lords. He is the TLO.
Date of demand is 4/9/1998 as per FIR.
Yes.
FIR mu katha kochi.
Ma'am.
But the injury report received
on 24
by ASI on 24/8/1998.
yes
My lords, to this
and discharged by 28/8
and my lords, to this query, let me further clarify, my lords.
Yes.
Lords, we kindly come to page 67, the oral testimony of PW6, the TLO.
67.
Yes, lords. My lords, the sentence starting with thereafter. The fourth sentence, my lords, from the above.
Fourth, yes.
Yes. Thereafter, I seized the notes with Exhibit 3. This is my signature on Exhibit 3 marked as Exhibit 3/2. I have also seized the medical certificate, my lords. I have also seized the medical certificate issued by the accused in favor of the complainant on 14/9/98.
No.
My lords, injury report and medical certificate are distinct.
Just a minute. I have seized I have seized the medical certificate issued by the accused in favor of the complainant dated 14/9/1998 and prepared the seizure list exhibit 4 हला वर्तमान exhibit 4 को आसीबा ए येटा एलसीआर ट्रायल कोर्ट exhibit 4 2 3 4 देखो 4 रे कोन लिखा है one medical certificate issued by Dr. Pradeep Kumar Praharaj,
accused,
dated 14/15/1998, issued to the complainant today on 14/9/98
yes,
with his signature and signature of the complainant.
Then and there he has issued.
Yeah.
Then and there the doctor has issued the medical certificate.
No, it's all right. Where is that document?
But this is the medical certificate, my lords.
Which one?
It's Exhibit 4.
No, Exhibit 4 is the seizure list. Seizure list of that document. Medical certificate tar document ta hochi se document ta seize heichi with this seizure list Exhibit 4. So let us say that where is the document itself? That document you have proved only two medical documents. That means one is the requisition.
Yes.
The other is the
injury.
No, that is bedded ticket.
Bedded ticket. Yes.
Right.
Yes.
So exhibit 10 ta ko chhad diyantu. Now you come to that bedded ticket which has been marked as exhibit
13.
13.
13. Let us come to that. 13(1)(3). 11 12 এটা 13 ସେଇ ଯୋଉ ଡକୁମେଣ୍ଟଟା ନୁହେଁ ଯୋଉଟା ଏକ୍ସିବିଟ୍ ମାର୍କ ହେଇଛି 13 ନା କଣ ଅବିକା ଯୋଉଟା କହୁଥିଲେ
Bedhead ticket.
ବେଡେଡ୍ ଟିକେଟ
Yes.
ବେଡେଡ୍ ଟିକେଟରେ ବେଡେଡ୍ ଟିକେଟ ସିଜ୍ ହେଇଛି
ଆଜ୍ଞା
ଅନ୍ 14/9/1998 ସେ ସିଗ୍ନେଚର ଅଛି ଇନ୍ସପେକ୍ଟର ଭିଜିଲାନ୍ସ ର ଏପଟ ସାଇଡ୍ ରେ
ଆଜ୍ଞା
ତେଣୁ ସେଇ ରେଫର କରୁଛନ୍ତି ସେ ଏକ୍ସିବିଟ୍ 13 ଟାକୁ ଏ ଯୋଉଟା ସିଜର ଲିଷ୍ଟ ଏକ୍ସିବିଟ୍ 4 ରେ ଯୋଉଟା ସିଜ୍ ହେଇଛି
ଆଜ୍ଞା।
ଦ୍ୟାଟ୍ ଇଜ ଦିସ୍ ଏକ୍ସିବିଟ୍ 13
ଓକେ
ତେଣୁ କ୍ୱେଶ୍ଚିନ୍ ହଉଛି ଯେ ଏଇ ପର୍ଟିକୁଲାର ଡକୁମେଣ୍ଟ ଯାହା ଦେଖଉଛି ଯେ ଚିକିତ୍ସା ଏବଂ ଡିସଚାର୍ଜ ଇଏ ସବୁ 28/8/1998
ଏଥର
ବେଳକୁ
ହେଇଛି ସବୁ
ସରି ଯାଇଥିଲା
ଆଜ୍ଞା
ତେଣୁ 4 ତାରିଖ ଦିନ ବାକି ଯୋଉ କହୁଛନ୍ତି ଆପଣ
300 ଟଙ୍କା
Demand
300 ଟଙ୍କା
on discharge.
ହଁ you see bedded ticket ordinarily the suppose somebody has sustained injury
Ma'am.
the requisition is sent that's a particular format
from the
in the other side of the requisition they used to fill it up that what are the injuries
Hmm.
suppose somebody remains in as an indoor patient then the question of bedded ticket will arise otherwise if the same day he is
Discharge,
treated
First
OPD
aid
so that will be mentioned there so here that requisition which has been marked as se jota
Bedhead ticket 13
nahi nahi bedded ticket nahi requisition ta mark heichi actually
So exhibit 10.
ହେଲା ଏକ୍ସିବିଟ୍ 10 ଟା ହଉଛି ଡେଟେଡ୍ 24/8/1998 ରେ ତେଣୁ 24/8 ରେ ସେଟା କରବୋରେଟ୍ କରୁଛି କୋଉଟା ନା 24/8 ରେ ସିଏ ଆସି ଆଡମିସନ ହେଇଛି ଆମର ହସ୍ପିଟାଲରେ ଏବଂ ସିଏ ଟ୍ରିଟମେଣ୍ଟ ହେଇଛି 3-4 ଦିନ
24 ରୁ 28
24 ରୁ 28
ଆଜ୍ଞା
ଯଦି ଆପଣଙ୍କର ସେ ତାର ଯିଏ ଇନଭେଷ୍ଟିଗେଟିଂ ଅଫିସର ଯିଏ ଏଏସଆଇ କହୁଛି ସିଏ ହଉଛି ସେ କେସ୍ ର ଇନଭେଷ୍ଟିଗେଟିଂ ଅଫିସର ତାର ଷ୍ଟେଟମେଣ୍ଟ ମଧ୍ୟ ରେକର୍ଡ ହେଇଛି ଯୋଉଟା କି ତାକୁ କନଫ୍ରଣ୍ଟ କରିଛନ୍ତି ଏମାନେ ପେପର ବୁକ୍ ଟା ଆସିଲା
It's 17
ପେଜ 70
70
କେତେ
ରେ
70 ତ
ଆଜ୍ଞା
ହଁ as per the complaint the accused had been demanding rupees 400 as bribe for sending the injury report to the police station. ASI PC Nayak, this man is the investigating officer of that case, had stated before me that he had received କାହିଁକି ନା ଆପଣ ଆଉ ଥରେ ଆସିଲେ PC Nayak ସେଇ ଯୋଉ ଏକ୍ସିବିଟ୍ ଟାକୁ ଆସିଲେ
ସେ bedded ticket
ନାଇଁ bedded ticket ନାଇଁ requisition ଟା
exhibit 10.
10 my lord
a requisition has been issued by that ASI
yes on
PC
24/8/98
24/9/9
So he is confirming that he has already
bedded ticket ଟା ସିଜ୍ ହେଇନଥିଲା you are right that bedded ticket ଟା
ଆଜ୍ଞା
ସିଜ୍ ହେଲା 14 ସେ ଯୋଉ ଡେଟ୍ ଦିଆ ହେଇଛି
ଆଜ୍ଞା
sure
14/9/98
14
ସେ ଅଲଗା ଗୋଟେ ୱିଟନେସ୍ ବି କହିଛି ଅନ୍ୟ କିଛିଟା ଡକ୍ୟୁମେଣ୍ଟ ବି ଇଏ ହେଇଥିଲା
ତେଣୁ
Seize
ବେଳେ ବେଳେ ଆଇଓ ମାନେ ବେଡେଡ୍ ଟିକେଟ ଟାକୁ ପରେ ଇଏ କରନ୍ତି ତେଣୁ ଏଠି ଯଦି ଆକ୍ୟୁଜ ମନେ କରନ୍ତୁ ଆରେଷ୍ଟ ହେଇଗଲା ବେଲ୍ ମୁଭ୍ ହେଲା ତ ତେଣୁ ପ୍ରଥମେ ଗୋଟେ ଇନିସିଆଲି ଗୋଟେ ରିପୋର୍ଟ ଚାଲିଯାଏ
ଆଜ୍ଞା
ମନେକର ସେତେବେଳକୁ ପେସେଣ୍ଟ ଟ୍ରିଟମେଣ୍ଟ ଚାଲିଛି
ଚାଲିଛି
ତ ସରିଗଲା ପରେ ତାପରେ ବେଡେଡ ଟିକେଟ ଇଏ ହୁଏ ତେଣୁ ଏଇ ଯୋଉ ବେଡେଡ ଟିକେଟ ଟା ଯୋଉଟା କି ଦେଖୁଛି
ଆଜ୍ଞା
ଯେ 24 ତାରିଖରେ ଇଏ ଆଡମିସନ ହେଇଛି
28 ତାରିଖ
ଏବଂ
discharge
28 ତାରିଖରେ ଡିସଚାର୍ଜ ହେଇଛି ସେଇ ଡକୁମେଣ୍ଟ ଟା ପର୍ଟିକୁଲାର ଡକୁମେଣ୍ଟ ଟା ସିଜ୍ ହେଇଛି 14/9/98
98
ହେଲା ଯୋଉଥିରେ କି ଡାକ୍ତରଙ୍କର ସିଗ୍ନେଚର ମଧ୍ୟ ଅଛି ଡାକ୍ତର ମାନେ ଦିସ୍
accused
ଭେରି ମ୍ୟାନ୍ ହଁ
apparent
ତାର ସିଗ୍ନେଚର ଅଛି that means this particular document was available in the hospital itself till 14th
yes
In his office.
right but that doesn't mean that the ASI has not received any other document ତେଣୁ ସେ ଯୋଉ ଡକୁମେଣ୍ଟ ଟା that's a different document ଏଇ ଡକୁମେଣ୍ଟ ଟା ଅଲଗା ଡକୁମେଣ୍ଟ
so that is the nomenclature is different here they say injury report there it says by medical certificate
ହଁ এইটা ଆକ୍ଚୁଆଲି ଇଞ୍ଜୁରି ରିପୋର୍ଟ ନୁହଁ ଏଇଟା ହଉଛି ବେଡେଡ ଟିକେଟ ଟା
ଆଜ୍ଞା
ଏଇ ଯୋଉଟା ଆପଣଙ୍କର ଏକ୍ସିବିଟ 13 ଦେଖୁଛନ୍ତି
ଆଜ୍ଞା
ହଁ
ସେ medical requisition ଟା exhibit 10 ଟା ଭୁଲ ସେ ଲେଖା ହେଇଯାଇଛି injury report in the list of exhibit.
that is a requisition clearly ଜଣା ପଡୁଛି କାରଣ ତାର ଲାଙ୍ଗୁଏଜ ହି ହଉଛି ସେଇଆ
ଆଜ୍ଞା
ତାର ଲାଙ୍ଗୁଏଜ ହଉଛି
complainant ନା ଲେଖା ହେଇଛି
ପ୍ଲିଜ
accused ନା
ଏକ୍ସାମିନ
ଲେଖା
ଆଣ୍ଡ ଓପାଇନ ଦି କଜ that is the requisition
Requisition.
ହଁ
admitted
see that cannot be medical
Report.
report.
ସେଇଟା ଭୁଲ ସେ ଲେଖା ହେଇଯାଇଛି sir.
that is wrongly mentioned
ଆଉ କି witness ନାହାନ୍ତି
yes Mr. Rijvi, what is your submission in this case
My lords, as far as the factum of demand is concerned, my lords, I am relying on that judgment which I have placed before your lordships. Secondly, my lords, the oral testimony of 2, 5, and 6 seems to be specifically and unequivocally declares regarding demand. 2, 3, 5, 6.
Yes, sir.
And it corroborates with each other.
PWs 2, 5, and 6.
Yes, sir. And 3 also, my lord, up to some extent regarding the prior demand. Evidence of PW2 assumes overwhelming support from oral testimony of PW4 and 6 also. Then thereafter, as far as the acceptance part is concerned, I am relying upon the CE report. And thirdly, as recovery is concerned, my lords, the oral testimony of PW3, 5, and 6, my lords, they candidly say about the recovery part.
Recovery kiye kouchandi apna PW?
PW3, page 56, my lords.
Okay. That was recovered from that calendar.
Yes, lordship circle.
And calendar also that
Yes.
changed the color.
Change the color. And PW5, page 61, my lords. That recovery part is all there. And PW6, page 66. My lords, here the demand, acceptance, and recovery has been proven.
Okay. Yes, anything you want to say? Any decision?
Yes, your lordship. Lordship, I have given a judgment.
Yeah?
And it's
Which paragraph?
Well, the para 10, your lordship, mein kind. Is it 2020?
in fact, my lords, subject to your lordship's leave, my lords, I am also relying on a judgment, my lords.
Okay. You have given this particular judgment?
Yes, no judgment I have given, my lord.
Yes, on any other door?
Any other is, my lord, this recent Supreme Court judgment, your lordship knows. Neeraj Datta versus State. Neeraj Datta versus State, Government of NCT of Delhi.
Neeraj Datta. What is the reference?
It's, my lord, 2020-22.
2022.
Live Law SC.
Live Law SC.
1029.
Yes.
And I'm relying on paragraph 68 onwards, my lord.
68 onwards.
More specifically, 68 clause F and G.
Just mark it and pass it on to me.
Yes, my lord.
Just I'll go through your decision. First, let him finish.
Yes, sir.
So you are relying on two decisions. One is that B Noha.
Yes.
And
my lord, Neeraj Datta. And my lord, one more decision, my lord, Vinod Kumar decision. Lordship knows about that.
B Noha.
Vinod Kumar, my lord, 2015 Criminal Law Journal 1442
Vinod Kumar
versus State of Punjab.
State of Punjab. Yes. So what is the reference?
2015
Criminal Law Journal
1442.
1442. Which paragraph?
And that is paragraph 9.
Have you given that book to me? Or
No,
you,
yes, I haven't.
it is available with you?
Yes.
All right. Which paragraph? Just tell me.
Para 9,
Yeah.
33,
Hmm.
29. Because here, Lordship knows here the complainant has turned hostile in this case.
Okay. Yes, you placed reliance on this K. Shanthama versus State of Telangana.
Not para 10.
Paragraph 10, yes.
May I state, Madam?
Yeah.
We have given careful consideration to the submissions. We have perused the depositions of the prosecution witnesses. The offense under Section 7 of the PC Act relating to public servants taking bribe requires a demand of illegal gratification and acceptance thereof. The proof of demand of bribe by a public servant and its acceptance by him is sine qua non for establishing the offense under Section 7 of the PC Act. In P. Satyanarayan Murthy versus State of AP, this court has summarized the well-settled law on the subject in para 23. And I quote, the proof of demand of illegal gratification thus is the gravement of the offense under Section 7 and Section 13(1)(d) Roman I and 2 of the Act. And in absence thereof, unmistakably the charge thereof would fail. Mere acceptance of any amount, allegedly by way of illegal gratification or recovery thereof, dehoards the proof of demand. Ipso facto would thus not be sufficient to bring home the charge under these two sections of the
10
Act.
and 11 you are relying.
Yes, sir. 10, 11, then 14.
14.
Yes, my lord. I'll just read it, my lord. PW1 describe how the trap was laid, similar to here, my lord. In the pre-trap mediator report, it has been recorded that LW8, Sri R. Harikishan, was to accompany PW1 complainant at the time of offering the bribe. PW7, Sri Raju, deposed that PW8, the Deputy Superintendent of Police, had instructed LW8 to accompany PW1 complainant inside the chamber of the appellant. PW8 has accepted this fact by stating in the examination in chief that LW8 was asked to accompany PW1 and observe what transpires between the appellant and PW1. PW1 in his evidence accepted that only PW1 entered the chamber of the appellant and PW8 waited outside the chamber. Even PW7 admitted in our cross-examination that when PW1 entered the appellant's chamber, PW8 remained outside in the corridor. Thus, LW8 was supposed to be an independent witness accompanying PW1. In breach of the directions issued to him by PW8, he did not accompany PW1 inside the chamber of the appellant and he waited outside the chamber in the corridor. The prosecution offered no explanation why LW8 did not accompany PW1 inside the chamber of the appellant at the time of the trap. Now, my lord, para 16. The next page. Thus, PW1 did not state that the appellant reiterated her demand. This is when he met her, my lord, at the time of trap. His version is that on his own he told her that he had bought the amount. What is material is the cross-examination on this aspect. In the cross-examination, PW1 accepted that his version regarding demand made by the appellant on various dates was an improvement. Now, my lord, they have quoted the entire cross-examination. Then at para 17. Thus, the version of PW1 in examination in chief about demand made by the appellant from time to time is an improvement. As stated earlier, LW8 did not enter the appellant's chamber at the time of trap. There is no other evidence of the alleged demand. Thus, the evidence of PW1 about the demand of bribe by the appellant is not at all reliable. Hence, we conclude that the demand made by the appellant has not been conclusively proved. Now, para 20 and 21. Thus, this is a case where the demand of illegal gratification by the appellant was not proved by the prosecution. Thus, the demand which is sine qua non for establishing the offense under Section 7 was not established. Hence, the impugned judgment will have to be set aside. Now, my lord, my humble submission is in this particular case, my lord, the FIR originally states that demand was made for giving injury report and for treatment. As your lordships has already found, my lord, treatment was over by 28th. So there was no occasion of giving a demand on 4th. Now, injury report, as has been stated in the cross-examination of PW7, that was received on 24/8. So there is no occasion of a demand. Even at the time of the transaction, no independent witnesses have gone, as in this case. So, my lord, here, even if recovery is accepted, even if acceptance of money is accepted, because the demand is completely, my lord, has no legs to stand, this judgment is relevant, my lord. My lord, I've got one more judgment. This is a 3-judge bench, my lord.
Yes.
This is a 3-judge bench of the Honorable Supreme Court, my lord, 2014, at para 7, my lord. Similar thing, my lord. My lord has para 7, my lord.
Yeah.
Insofar as offense,
same thing. Why are you repeating?
Same thing, my lord. Same thing. My lord, the only thing is, they again here also say at the bottom of para 8, mere possession and recovery of currency note, although this is from the accused without proof of demand, will not bring home the charges. That's the.
No, law has gone to the extent
Yes, sir.
that suppose even the decoy turns hostile,
Yes, sir.
otherwise it is proved the case, then also the conviction can be sustained. So, because why it is it has been said so, because he's an outsider. That means he's an independent person. He's so maybe that at one point of time he had grievance. He cooperated with the vigilance people, and the trap was also successful. Then somehow or other he was gained over.
Yes, sir.
So that is why there is possibility of his residing back.
Yes, sir.
So in that way, if we accept that merely because the complainant did not support the prosecution case, the entire case has to be discarded, then there would be an attempt from the side of the accused to gain over only one witness, then entire thing will go.
Completely.
Right? That is why they say that no, it would not be authorized if it is the case is proved. Suppose somebody, even if the complainant turns hostile, then obviously there would be no proof of demand part.
Yes, sir.
That is why they have used that language that if you have voluntarily accepted
or obtained.
and obtained, that will also show that there was demand.
Yes.
That would be a part of it. Otherwise, why did you voluntarily and accepted? Why didn't you object? You are a public servant. You have done your duty. Why you will accept money, right? So if it is not the legal remuneration,
yes, sir.
So that they have gone to that extent. Like they in the NDPS Act cases, they say that even if the independent witnesses turn hostile, okay, on the basis of the official witnesses to the search and seizure also conviction can be sustained. Why they said so? Because the independent witnesses in almost 90% cases, they are not supporting the prosecution case. So if we'll fix a dictum, we'll give a dictum that unless the independent witness support the, so that is not, that is why looking at the circumstances, the society, the law changes from time to time because of it. So now here, if we find FIR version, whatever is maybe, it has been given a go by. We can say that it has been given a go by in the deposition of the complainant.
Yes, sir.
Because in that case, it was there for 500, 100 was paid, 400 remained, then that was a concession.
Date of admission and date of discharge was different.
So that is not there. That part is totally not there. Then the second part, that in the what has happened in the on that date of that decoy is not corroborating to the preparation part. He is totally silent. And so far as demand in the spot on the date of occurrence, his evidence is also silent. His evidence silent, and the evidence of the overhearing witness is also overhearing witness was outside. But one thing is there
But the
that
decoy says, my lord, the decoy says that the accused told me to keep the money on the table. That is there.
no, he instructed me.
Yes.
The language is instructed me, and I accordingly kept.
I kept the money on the table.
Right.
Then in cross-examination, he says that he has not demanded any money.
So now the decoy does not say anything about the instruction given,
Yes.
but rather say that only he came and told me that he escaped.
Yes.
At that point of time, also the complainant, he did not say that complainant told me
To keep
that
the
on the
table.
instruction of the accused,
I kept the money on the table.
money.
Yes.
That part is also not there. Then the conduct of the accused, when he was confronted, all the witnesses have stated that he said
denied.
that no, he denied to have demanded. So that is one aspect about the conduct. Then about this hand wash taken, we have already discussed that it was not sealed
properly.
Some persons have not totally stated about
The sealing of
this. Hand wash being taken.
Hand wash being taken.
And whosoever has taken about the hand wash being taken, like the two TLO and the other
PW3,
they have also not stated that it was sealed at the spot, and the seal was obviously made in presence of a OPS that OS officer in the vigilance office, because he was not present at the spot.
Yes.
So these are the circumstances, and apart from that, he said that for medical treatment, somebody is demanding.
Yes,
because you are two things you are saying. One is to send the injury report, and for যদি নক করিব মু তাহলে মেডিকাল ট্রিটমেন্ট করিবি নাই তো সে কয়া কথা যে 4 তারিখ 28 ତାରିଖରୁ ଯଦି ସେ ଡିସଚାର୍ଜ ହେଇଗଲାଣି ତେଣୁ ଆଉ ଟ୍ରିଟମେଣ୍ଟ କରିବ ନାହିଁ କଣ ତେଣୁ
even as accepting his version of the FIR, if at all, he said 4 ତାରିଖ ବାହାରିଲା ସେ ଯେ ଯଦି କେବେ ବାହାରିବ ତାକୁ କହିବା ହବ କାହିଁକି ଯେ କି ଆପଣ ଆସିକି ପୁଣି ମତେ ପଇସା ଦିଅନ୍ତୁ otherwise ଆମ ଟ୍ରିଟମେଣ୍ଟ ପୁରା କରିବେନି. Even in his statement,
declared hostile.
No, that's
statements are not
one more thing is that the one person who has not been declared hostile,
PW3,
overhearing witness, he has made many damaging statement against the prosecution. So even after the cross examination also, if he says something differently which favors the accused, you can always re-examine the witness. He says something in the chief examination, gives a different version in the cross. That is the reason why re-examination is there. You should clarify it. That has not been done. So that witness who has not been declared hostile also, and hostile witness evidence cannot be totally thrown away. It has
can
to
be taken up
right.
to some extent.
Just two more things,
This is what Vinod Kumar's case also says.
Yeah.
The Lordship's version is there in the Vinod Kumar case also.
Right.
This is what they say also.
My lord, one aspect, as your lordship read from the statement of the accused, from that position till throughout the trial, he's been saying that his brother, the complainant's brother, Tumeshwara Nayak, I mean, my lord, our case is this all happened because I was part of a committee in which his age determination was there for rehabilitation and resettlement. He apparently did not get it. So in spite, this is all has been manufactured. Now, my lord, that we had also produced a witness. If my lord may kindly have a glance for 1 minute. Page 72.
You have examined it.
Yes, my lord. Only one.
Suresh Chandra Mahapatra.
Let
my lord may kindly have page 72. I just want to...
Just a minute.
Yes.
Okay. Yes.
Yes, may I read it, my lord? As per the notice, I am producing the proceedings of the Age Determination Committee of Village Benakhamara held on 6/8/94. Village Benakhamara had submerged under the water due to Upper Indravati Hydroelectric Project.
persons above 18 years of age as on 1/1/90 were entitled to compensation as per rehabilitation policy of the government in the submerged area on account of irrigation project. And accordingly, a list of persons were prepared on 6/8/94 relating to village Benakhamara by a committee consisting of project director, doctor and other members. This is that list marked as Exhibit A. The above list was in the custody of project director RNR Rehabilitation Resettlement, Khatiguda. It appears that Tumbeswara Nayak, son of Kumar Nayak of village Benakhamara, Wide serial number 33, was aged about 20 years as on 1/1/94 and was not entitled to any compensation. Mr. P.K. Praharaja, medical officer, was a member of that committee, and I am acquainted with his signature in the signature, and this is the signature.
यार कौन थिला जे 18 वर्ष
up to 18 years.
18 वर्ष पर हेइगला
As
पर
on 18 ବର୍ଷ as on 1/1/90.
1190
Yes.
ତେଣୁ ଇଏ ହେଲା
1/1/94.
1190 ରେ ତାକୁ 18 ବର୍ଷ ହେଇନଥିଲା
ହେଇନଥିଲା,
କାରଣ
20 years.
ତାକୁ 20 ବର୍ଷ ହେଲା ଯଦି 1/1/94 ରେ
ଆଜ୍ଞା।
ତେଣୁ 1190 ତାକୁ 16 ବର୍ଷ ହେଇଥିବ
Yes.
ସେଥିପାଇଁ ସେ କମ୍ପେନସେସନ ପାଇବାକୁ ହକଦାର ନୁହେଁ ଯୋଉଥି ପାଇଁ ରିପୋର୍ଟ ଟା ମଧ୍ୟ ପ୍ରିପେୟାର ହେଇଥିଲା ଯୋଉ କମିଟିରେ ଇଏ ମେମ୍ବର ଥିଲା
ଆଜ୍ଞା ତ ସେଇ ଆମେ ସେଟା ଦେଇଛୁ ତାପରେ କ୍ରସ୍ ଏକ୍ସାମିନେସନ ସେ କହିଛି I was not part of that committee and so on and so forth.
The cross is also important, my lord.
I'll read it out. I was not present at the present place of posting in the year 1994 when the committee was formed. I have no knowledge about the member constitute the above committee. I cannot say for what purpose the committee had been formed. As per the records, it was for determination of the age of the applicants. It appears that other applicants of the list also been disqualified. It appears that signature of other committee members are available against their entries of the list. I cannot say if applications of the above persons are available in the file or not. I cannot say if the above list had been meant for providing any compensation in the rehabilitation process.
He is not able to say about the very factum of the list, my lord, the veracity of the list, for what purpose it has been made.
No, my lord. He says.
So we are reserving this judgment. That's all. Anything you want to give, you can file your written note.
Yes, your lord.
But don't make it late. File it by maximum by Monday.
Your lord.
You are getting 2 holidays.
Your lord.
Yeah, Mr. Rizvi, if you want to file any
Those citations are enough for my sake.
citation, I just got only one citation.
I am handing over the rest of the
Please hand over that.
Well, there is also a small note. I had it is there. I'll give a separate note. I'll give a fresh note.
ଆଜି ଯାହା ଡିସ୍କସନ ହେଇଗଲା ତାକୁ ଆଧାର କରିକି
ଗୋଟେ ଫାଇନାଲ ନୋଟ ଆଉ ଜଜମେଣ୍ଟ ଦେଇକି
ସେ ଯୋଉ ଜଜମେଣ୍ଟ ଦଉଛନ୍ତି ମିଷ୍ଟର ରିଜଭି ତାଙ୍କୁ ଲେଖିଦିଅନ୍ତୁ ଏଟା
I have handed over the judgment.
Please hand over so that I can write that this is the results. You have given only one decision.
मतलब 2 decisions. K. Shantama and P. Jayar.
All right.
Jayaraj.
So likhi diyantu.
My lords, apart from this, my lords, one judgment is that T. Shankar Prasad that has been taken note in the judgment itself with learned code below. So I'm not giving an extra work.
Okay. Mr. Satyasmruti Mahanti, Land Counsel for the Appellant, and Mr. M.S. Rizvi, an Additional Standing Counsel for the Vigilance Department. The Land Counsel for the respective sites filed and the citations which are taken on record. The Land Counsel for the Appellant, however, submit that he will file a written note of argument by 7th August 2023, giving copy of the same to Mr. M.S. Rizvi. Hearing closed, judgment is reserved.
Gratefully.
Deeply obliged.
So, yes, Mr. Das, your item number 2. So, who is the respondent counsel? We'll take up after lunch.
Yes,
okay.
My lord.
Item number 2, may I please your lordship? My lords, this is a trap case, my lord, and the accused was let off by the London trial courts, primarily for 4 grounds, my lords. I will apprise to your lordship one by one. And the state vigilance has prepared this petition, my lords. And because of the statements recorded of the decoy and the shadow witness, my lords, who stood boldly behind the prosecution case, the leave was granted. And now, if your lordship, my lords, to place your lordship, what are the factum of perversity, my lords? Let me place, my lord, what are the grounds for which the accused, in fact, with regard to the accused, my lord, the accused was working as an auxiliary nursing midwife. In short, as NMR. Nowadays, they are being called as multi-purpose health worker, my lords. And she was working in Manikogoda PHC, public health centers, not at Bolgod, under the Bolgod police station in Khurda district. And the relevant date is the 7/9/2010. On that day, the wife of the decoy was admitted in that same Manikogoda PS wards and gave birth to a child at 11 p.m. And on that same date, the accused ANM assisted the doctors during the delivery of the child, and the accused demanded that illegal gratification of 500 rupees to the complainants for delivery of for delivery charges, and 50 rupees for supplying the check. Check pertains to a particular scheme known as Janani Suraksha scheme. In that scheme, lords, 1,400 is to be paid to the woman delivering a child, lords. That, lords, the second case is the prosecution is that on 24/9/2019, the accused had a negotiation with the complainant's notes, and the demanded amount of 500 rupees reduced to 400 rupees to be paid on the next date, that is on 25/9/2010. That's the date of trap also. A successful trap was laid, and she was caught red-handed, notes. And both the decoy and the shadow witnesses, they extended full solidarity to the prosecution case with regard to the factum of demand, factum of acceptance, and also recovery. And, my lords, the chemical agents reports as well as the TOLS evidence also fully corroborate each other's, my lords. And now, if your lordship permits me, what are the grounds, 4 grounds, my lords, for which the accused was let off by the London Trial Court? The first ground, my lords, I'll place, my lords, that at page 21, the finding starts of your lordship brief, my lords. Page the paper book, page 21, where the finding starts. The first ground, I'll put in short the 4 grounds, thereafter I'll place the entire thing. First ground, that why the complainant didn't inform to the medical officer regarding this illegal gratification demand. 2, there was no pre-demand illegal gratification, no pre-demand of illegal gratification. Third ground is that why the right hand wash sodium carbonate solution didn't turn to pink colors. And the fourth ground is that why the complainant wife who delivered the child was not examined. These are the 4 grounds for which the London Trial Court, while brushing aside the trusted evidence of the decoy and the shadow witness, also the TLO, lords, also the chemical agents reports, my lord, in fact, let off this accused, my lords, only these 4 grounds. Now, if your lordship permit me to place the page 21, where the finding starts. May I have the permission to place that, my lord?
Yes, yes.
Page 21, lords. In fact, it starts from 7/9/2010 till date. Yes. Sorry.
Yeah.
May I place from paragraph 8, or should I yes, on the bottom portion of the paragraph 8 minutes?
Yes, yes.
In view of this, I'm placing this 5th line from the bottom of page 20. In view of this, did your lordship get it, minutes? 1, 2, 3, 4, 5, 6, 7 lines from the bottom, page 20. In view of this evidence, it is found the complainant has not come to the court in clean hand. He has suppressed the fact of not supplying the required documents which was the cause of non-granting of check under Janani Suraksha Yojana. In these circumstances, the plea of the complainant that the check was not issued on demand of money cannot be accepted. More so, PW1, the medical officer also states never after 7/9/2010, that's the date of delivery, till the date of trough, the mother of the child had come to the hospital to collect the check. For the sake of argument, this is the finding. If it is considered that if the complainant's wife was harassed by the accused in a month by not issuing the check, then no reason is found as to why she had not brought this fact to the notice of the PW1, the medical officer. This also creates suspicion regarding the plea of the complainant. This is one of the grounds for which the accused was acquitted. And the second ground starts from para 9. Further argument advanced by the learned counsel for the accused is that there was no previous demand. And in a trough case, in absence of previous demand, the case of the prosecution cannot be relied upon, to which it is answered by the learned special PP vigilance that in the complaint petition, as well as the evidence of PW3, the complainant clearly speaks about the same. Para 10. It is found from the evidence of PW1 that at the time of discharge of Laila Begum, the wife of the complainant, after her delivery on 7/9/2010, he, along with the accused Sanjubala Raut and ASA worker Istafa Begum and male sweeper Bikram Naik were present. The same fact is also admitted by PW3 in his cross-examination, though it denies the presence of sweeper Bikram. So, at what time the demand of illegal gratification was made to the complainant is not understood. More so, the evidence of PW1, the medical officer, shows the accused was all along with him at the time of delivery, and therefore, so the pre-demand of bribe by the accused, the complainant fails to prove. In view of the evidence on record, after 7/9/2010, that's the date of delivery, till 25/9/2010, that's the date of trap, the complainant and his wife had not come to the hospital. How the deal of bribe of rupees 400 was decided between the parties is not clear. It is hard to believe. The same fact is also not clearly mentioned in the complaint or the complainant, nor his statement before the IO, and in the court does reveal about the same. The evidence of PW7, the independent official witness, reveals the complainant narrated the accused demand rupees 500 for sweet on the occasion of the birth of his son and rupees 50 for issue of check. The evidence of PW7 throws doubt on the plea of the complainant because asking money for sweet on the happy occasion of birth of a son cannot be treated as demand for illegal gratification, and for that, delaying the issuance of check is not acceptable. From the evidence of IO, it is found that he has not laid his investigation to find out whether the allegation of the complainant was true, because in view of the discussion in the foregoing paragraph, suspicion arises in respect of allegation of the complainant. Para 11. It is the evidence of PW3 that when he, along with his wife, entered inside PHC, the accused called them to the nearby shop center where the transaction took place, and it is the case of the prosecution that PW7, the overhearing witness, was in close proximity of the complainant to hear their discussion and see the transaction and immediately to give signal. The evidence of other PWs shows that when the complainant and his wife were in the sub-center along with the accused, they had taken their possession in close proximity. The evidence of the complainant, PW3, shows the accused received money in her right hand and transferred it to left hand, and all of them came outside after the check being issued to the to take counter signature of PW1 on it when the vigilance officials trapped her. No reason is found as to why the accused was not trapped in the sub-center itself, and the vigilance officials waited for her to come to the doctor. This creates a very serious doubt on the genuineness of the trap. In the circumstances of plea of the defense appears to have forced that finding the money on her table when the accused rushed to the doctor to disclose the same, she has trapped by the vigilance officials. The trap became more suspicious when the evidence of PWs come to show that the right hand wash with sodium carbonate solution didn't turn to pink colors, but her left hand wash with the said solution turned to pink, though there is evidence that accused had received money in her right hand and then transfer the same to her left hand. The plea of the defense that accused have some ill feelings with one of her colleagues, Sodamini Malik, relating to the allotment of quarters, who was close to Julfikar Ali, and at the instance of that Julfikar Ali, who was instigated by Sodamini, the complainant has filed a false complaint in the facts and circumstances cannot be overruled. Besides all these, Laila Begum, the wife of the complainant, who is a beneficiary under the scheme, and the actual person to receive the monetary assistance is not examined by the prosecution nor examined by the IO during investigation, and no reason advanced as to why she was kept withheld from the witness box. In view of my above discussion, I find the case of the prosecution is beyond doubt and fails to prove the case against the accused to guilt, and therefore I do not hold the accused guilty and acquit her from all charges. My lords, in essence, my lord, I reiterate with the lordship permission, there are four grounds of acquitting the accused person. One ground, if I start from the bottom, why the complaint wife was not examined. Then three, why the right hand wash with sodium carbonate didn't turn to pink. Then second miss, why the accused was not trapped in the sub-center itself. And my lords, the important is, my lords, if lordship turn to next page 21, there is no pre-demand of illegal gratification. And frankly, I said another ground at the top first paragraph 21 is that why medical office was not informed. The complaint, when he found that accused was demanding illegal gratification, he could have asked that doctor why that was not done. So these are the 4-5 grounds for which the findings, my lords. I humbly pray, my lords, I'm burdened for lordship, my lords, to appraise your lordship that these 4 findings are bristling with perversity, my lords. And perversity is when the findings are against the weight of evidence on records, my lords, my lord. That warrants the interference of the Supreme Court, my lord. Now, my lords, with regard to the first point of the findings, my lord, that is, there was no pre-demand of illegal gratification. On that, my lord, I would like to take your lordship attention to the statements of the decoy, the star witness for the prosecution. And if lordship get it at page 47 of lordship report, PW3 is a decoy. We have the permission to place page 47, the decoy statements.
Yes.
May I place me on page 47? That's the statements of the decoy, my lords. In fact, entire draft case revolves around the evidence of the decoy, my lords. May I place the page 47 of the paper book, my lords? Lords, I am the complainant of the case. I presented a report for the DSP Vigilance, Khurda, alleging Sanjeev Bala Raut, ANF, Manikagod Health Center, to have demanded illegal gratification rupees 500 for the delivery of my wife and rupees 50 to supply the check under the scheme, Janani Suraksha, sponsored by the government. Now the pre-demand starts. C demanded such gratification on 7/9/2010 when my wife delivered a male child in Manikagoda CSC. The second demand was in the date of draft, that is on 25th September 2010. So this is the first demand. C demanded such gratification on 7/9/2010 when my wife delivered a male child in Malikagarh CSC. These statements of the decoy, my lords, he stood the test of cross-examination, and this remains unshaken. In view of this, and another witness of the shadow witness also corroborated this one. For that reason, my lord, this evidence on records and the findings of the learning court that there is no pre-demand are bristling contradiction and resulting in the perversity. So warranting your lordship interference. When ECS specifically stated, the accused demanded such gratification 7/9/2010 when my wife delivered the male child in Manikagad police station. And if your lordship turn to one line to the evidence of PW8, the overhearing witness at page 73 also. There also, this overhearing statement stated, the complainant told that he was blessed with a son and he was to get financial assistance rupees 400 under Janani Suraksha Yojana, and the ANM, the accused, was initially demanding 550 to check rupees 400, and later on she reduced the demand to 400 to check. So there was evidence, clinching piece of evidence record, which unerringly indicates that there was a pre-demands with regard to this particular illegal gratification notes, and the pre-demand was on 7/9/2010 when the complainant's wife was admitted in the CSC Mullers on 7/9/2010 Mullers, and that's initial demand. On that particular, taking consideration these two evidence Mullers on record Mullers, which remains on second Mullers, the findings of the learning trial court that there was no pre-demand Mullers, this is nothing but a piece of perversity Mullers. Now, if your lordship permits me to come to the second findings of the learning trial court, that why the right hand wash with sodium carbonate didn't turn pink Mullers. This finding is also against the weight of evidence, because if your lordship can see the evidence of TLO at page 81, the entire tented money was recovered. I'm placing this one line. At my direction, the constable Balayar Singh prepared solution. This is the TLO statement. Sodium carbonate in both hands wash of the accused were taken separately, and in both cases, sodium turned to pink, which were preserved in separate clean glass bottles, which are marked L left and right. So it was recovered from the left hand Mullers, grief Mullers. If you lordship turn to the page 83 Mullers, on being proceeded to inside the healthcare in the office room, the tainted money was recovered from her late grief by witness Mohit Kumar Das with the assistance of Lady Inspector Lalita Parida. Late grief Mullers. Now, if you lordship turn to the evidence Mullers, at page 104 Mullers, one sealed glass bottle containing pink colored solution of the right hand wash of the accused Srimati Sanjeev Raut, that is marked K, marked R. Then the one sealed page, I'm reading 104 Mullers. This one sealed glass bottle containing pink color solution, that is left hand wash of the accused Sanjeev Raut, that is exhibit mark L. Lordship, to next page, that's a chemical agents report. The last line, it contained 4 numbers of sealed glasses bottles marked as exhibit D. R is relevant. R is the right hand wash of that accused Mullers. L L is the left-hand wash of the accused, my lord, and W, and each containing 8 ml of pink color slip. So, in fact, the statements of the decoy also narrate that both hands were washed. Decoy statements is at page 47, and he has stated also that thereafter the right hand and then left hand were washed with the chemical solution separately. The color of the solution turned to pink. This is decoy statement at page 51. The same thing has been corroborated by the shadow witness also, that is at page 73. Page 73, and I'm placing that one. Para 4, the lady vigilance inspector recovered 4 numbers of 100 rupee GC note from the left hand of the accused. Left hand. The both hand wash of the accused were taken in sodium carbonate solution separately, and both the solution turned to pink color, and solution are kept in 2 separate bottles and given mark L and R. So both the decoy and the shadow witness, with regard to the change of colors, they are unanimous in saying that the chemicalization and the hand wash turned to pink colors. Decoy and shadow witness, and fully supported by the scientific scientific officer PW5, and who in fact proof the chemicalization report at page 105. And if 105 says that exhibit RDRLM containing of pink colors liquid substance, and if it's read conjointly with the previous page, that is 104, that is a forwarding letters. One sealed glass bottle containing pink color in the right hand wash of the accused Srimati Sanjuvala Raut, that is marked exhibit R. The second is the sealed glass bottle of the left hand wash of Sanjuvala Raut, that is RL. RL has been reflected in the chemicals report, contain the pink colors. So with this particular evidence and record, the findings of the London trial court that right hand wash only and the other thing and the solution did not turn. The right hand wash with sodium carbonate solution did not turn to pink color. I'm placing page 23. But a left hand wash with the sodium turned to pink color. Though there is evidence that accused has received money in the right hand, and in fact it was recovered from the left hand grip notes. So, in view that this finding is also perverse, notes. Now, the third, I'm coming to the third findings, notes, that why he didn't inform the medical officer, why when the NMN demanded illegal gratification, why he didn't inform to the medical officer. Second, why the complainant wife was not examined. Third, why the trap was not held in that particular subcenters, why in that case. So these are the findings, my lord, and my lords, absolutely based on no evidence, my lord. And when the findings are not based on no evidence, that's also amounting to perversity, my lords, warranting a lordship interference, my lord. Now, if a lordship permits, my lord, may I place the full statements of the decoy, my lords.
Not full statement, just
I'll just element exactly. Let's turn to para 17. I will just place 3 lines in 2 paragraphs. That's all. Page 47 is the decoy statements, lordship paper book. 47. I am placing 47 just last few lines, my lord. It starts. C demanded such gratification. Did your lordship get it? No? Last line from the bottom. C demanded such gratification on 7/9/2010 when my wife delivered a male child in Manikagoda CHC. When I expressed my inability to pay such a huge amount, she reduced the demand to 400 rupees, stating that unless it is paid to her, the check would not be issued in favor of the wife. Thereafter, on 2 or 3 occasions, I approached the NMN and issuance of the check. She did not pay heed to it, but constant. I'm placing page 48, but constantly insisted me to pay for payment of the gratification of 400. Subsequently, on 24th September 2010, that's one day prior to the trial, When I again met the accused, she told me to bring 400 rupees on 25th 9 2010, so that she will issue the check. So this was the prior demand notes. Now let's return the real demand on the date of draft. Let's return to page 50 notes. Let's go to page 50.
Yes, yes.
This is relevant. I'm skipping the first two, 3 lines. The next line starts. Then myself, Lenka Babu, is a shadow witness, and my wife, Laila Begum, went to the PSC. We 3 went to PSC. I went inside the PSC. Accused was very much present. Seeing me, the accused out and called me to the sub-centers, which was a little distance from the PSC. I accompanied the accused to the sub-center while my wife and Lenka Babu followed me. Lenka Babu, the shadow witness, stood at the door. My wife entered into the room of the accused. The accused, important, asked if I have brought me cash and I agreed to it. Then she demanded the cash and had handed over the tented GC notes, but not the 4-folded papers to her, because the tented money was wrapped in 4-folded papers. She accepted the cash in the right hand and kept it in her left hand. Important, because when the act of recovery of the tented money from the left hand of the accused. Now, Lordship, this is the factum of demand and acceptance modes. Now, Lordship, turn to page 51. Page 50, I'm skipping the first 6 lines. The line starts thereafter. Thereafter, the right hand. Lordship, got it? I'm placing. Leaving the first 8 line of page 51.
There, side, there is a marking here.
Yes, Lordship, correct. Now, thereafter, the right hand and then the left hand were washed with the chemical solution separately. The colored solution turned to pink. Now, this was absolutely brushed aside by London Trial Court, holding that why one is pink, other is not pink. Now, Lordship, permit me to come to the shadow witness statements. I will also again in the shadow also place the relevant lines. Page 73 of Lordship reports.
Yes.
Page 73. Milords, I'm skipping the first 8 line. The line starts, in fact, 4th line from the bottom. The complainant told that he was blessed with a son and he was to get financial assistance rupees 1400 on the Janani Surakha Yojana, and the NM was initially demanding 550 to give the check of rupees 1400, and later on she reduced the demand to 400 to give the check. This pertains to the corroboration with regard to the pre-demands. The complainant also, the so and so. Let's turn to the page 75 notes. That's the relevant portion. In lots of turn to page 74, last line. Page 74, last line. Michel and the complainant and his wife enter inside the PSC. The complainant called the accused, Sanjubala Rao, who was inside the PSC. There was a room sub-center by the side of the PSC, which was within the PSC premises. The accused, page 75, the accused told the complainant and his wife inside that room. I waited outside the room. I found that the accused Sanjubala asked the complainant if he had brought the money, and the complainant answered in affirmative. The accused asked the complainant to give the money. The complainant gave the money. The accused took the money in her right hand and then caught the same with her left hand, because recovery from the left hands of grip. Then the accused scribed the check and gave the same to the complainant, asked him to get it signed by the medical officer. The complainant took the check to the medical officer, got it signed by him, and then brought the same to give the accused. Then the accused took the signature of the wife of the complainant in a register, handed over the check to her, wife of the complainant. By this time, I gave signal while Sanjubala was coming out the room sub-center. By then, the trap party rushed there and got hold of. Next paragraph. Being asked by the trap party about the receipt of money initially, the accused denied to have received any money, but later on admitted. The lady vigilance inspector recovered 4 numbers of 100 rupees GC note from the left hand of the accused, which was turned left. We all went to the sub-center. Both hand wash of the accused were taken in sodium carbonate solution separately, and both the solutions were turned to pink color, and the solution were kept in two separate bottles and given mark L and R. Now, my lords, I am not placing the further lines. To correlate this L and R, let's we turn to the page 105, the chemical agent report. 105 minutes. 105 chemical report. Lord. Last line, it contained, what she got it now?
Yes.
It contained 4 numbers of sealed glass bottles marked as exhibit DRLM, each containing 508 ml of pink colors liquid substance. Now, let's see which are the two hands. Let's turn to the left side to page 104 minutes. 104 on the top. Let's go that box left side minutes, page 104. One sealed glass bottle containing pink color solution, that is right hand wash of the accused Timothy Hanjwala. This is exhibit R. And about the R, the opinion rendered by the chemical scientific officer, this is after D, then R is that. It also contains a pink color liquid substance. Then let's turn to page 104, the second box, one sealed cover bottle containing pink solution of the left hand wash of the accused Sanjeev Rao, that is marked as exhibit L. About L also, after R, L is there in page 105 last line. That also contains the pink colors. And milords, with regard to the another important witness with regard to the factum of recovery is that is the TLO, that is page 81. I'll place a few lines only. Page 81. Let's see, got at page 81. That's at PW9, the TLO.
So, is he disputing the recovery part in the accused statement?
No. He said that one of the findings for which the accused was let off, that why only one hand was here.
That is correct. But what is his accused statement? What he has stated? 313 statement, what he has stated. What is that page number?
I'm placing that 313 or page?
313 statement, accused statement, page number? 35.
35, my lord.
35.
My lords.
Come to the accused statement.
Page 35. Question number 1. It transferred from the evidence of PW3, Mehboob Hussain Khan, that on 7/9/2010, his wife gave birth to a male child at Manikagoda, PSN, according to Janani Surakha scheme launched by the government. He is to receive 1400 in the form of check. What you have to say? It further transfer.
No, leave it. Say. Then you come to question number 16 and 17.
16. It transferred from the evidence of PW1, the medical officer, Manika Goda, PSC, that under Janani Surakha, the women who are coming to government hospital for delivery, they would take financial benefit, which is also applicable to his PSC. What you have to say? Yes. Then 17. It is further transfer from his evidence that it is your duty to issue Janani Surakha card to pregnant women and prepare the check of 1400 to be given to the woman after delivery, being countersign being. What you have to say? Sir. Question 18. It transferred from the evidence of PW5 that at the instance of S vigilance, a registered vigilance-based case.
No, you come to then question number 23.
Have you got anything to say in this case? Sabu kotha, sabu micha kotha, ta 7/9/2010 re Laila Begum
complainant
rosti health card dei parini
nei parila ni dei parilani na nei
parla. You have to show the health card, thereafter will get the check.
Oh, dei parlani.
Dei parlani. Kintu on 24/9/2010 Sedino Asi.
Jaya Wasintik is right.
Sedino Asi meeting ru dakile mu check dei toilet jaichi ମୋ ଟେବୁଲରେ ଟଙ୍କା ରଖି ଦେଇଛନ୍ତି। ସେ ଟଙ୍କାରେ ମୁଁ ସାର୍ଙ୍କ ପାଖକୁ ଗଲାବେଳେ ଭିଜିଲାନ୍ସ ଅଫିସର ମୋ ଟଙ୍କା ନବା କରି ମିଛ କେସ୍ ଦେଇଛନ୍ତି। ଭଲ କାମ ପାଇଁ ମୁଁ ଷ୍ଟେଟ୍ ଆୱାର୍ଡ ପାଇଛି। ମତେ ଟଲରେଟ୍ କରିପାରୁନାହାନ୍ତି। ମୋ କ୍ୱାର୍ଟର୍ସକୁ ସୌଦାମିନୀ ମଧ୍ୟ ନେଇଯାଇଛି।
Lordship permits, Lords, the essence of my submission is, Lords, when the illegal gratification was demanded and accepted, which is not the legal remuneration. That legal remuneration was consciously, it was demanded, it was accepted with pre-demand and on the demand after. Both the decoy and this shadow witness,
But
Lord.
you have not taken any specific plea. You have still about the false case.
Right.
So false implication.
How? Why you then? Money was recovered from you. Or why you have taken that money?
No, I am not. I am the plea of the accused not taken money, my lord.
The hand wash, etc. That was from the seizure list. How do you overcome?
It was on the table. Table, table.
That's all right. But your hand wash. You just said that he was pointing out from the C report. This 105 and the previously the one sealed bottle containing both hand wash of so and so constable, one sealed. अच्छा ये जो 2 नंबर 3 नंबर पेज 104 रे गोटे sealed glass bottle containing pink अच्छी तो अपन का देखिले 104 को आसंतु sealed glass bottle containing pink color solution, that is the right hand wash of the accused ହେଲା आ गोटे होची सेटा मार्क हेची R देखंतु सभा लास्ट को exhibit marked R, extremely right hand column. Then again the left hand wash, that is marked as L ହେଲା question पचरा हला exhibit marked as so and so
on the Janani Surgya Yojana card. Myself and the female health worker put signature on the check. After disbursement of the check to the beneficiary, the disbursement is mentioned in the disbursement register. On 7/9/10, Laila Begum, wife of Mehboob Hussain Khan, was admitted at our PSC under labor pain and was immediately taken to labor room. The female health worker Sanjiwala assisted me during the delivery of the child of Laila Begum on 7/9/2010. I am acquainted with the signature of the accused Sanjiwala. Under the requisition of the Vigilance Department, I had sent information to him relating to the guidelines of Janani Suraksha Yojana, the services particulars of the accused, admission and discharge details of the patient Laila Begum, etc. Under my letter number marked as Exhibit 1, Exhibit 1/1 is my signature thereon. Exhibit 2 is the Janani Suraksha Yojana card. Exhibit 2/1 is the signature of the accused. Exhibit 3 is the true copy of the appointment letter of the accused. Exhibit 4 is the true copy of joining report. Exhibit 5 is the attested copy of the extant copy of Indo register. Exhibit 6 is the attested copy of the bed head ticket. Exhibit 7 is the attested copy of outdoor patient register. Exhibit 3/1, 4/1, 5/1, 6/1 and 7/1 are my signatures. Exhibit 8 is the Xerox copy of the guideline of Janani Suraksha Yojana. Exhibit 9 is the Xerox copy of another guideline in respect of Janani Suraksha Yojana. A pregnant woman coming to our PSC is not required to pay any legal remuneration in order to get the check relating to Janani Suraksha Yojana. In cross-examination by the defense, at the relevant period, the accused was the in charge of immunization. She was continuing in our PSC since 2001. She was not in charge of delivery of child. Ranjita Das was attached to the hospital and was in charge of delivery of children. There is no official order directing the accused for delivery of child on 7/9/2010. Janani Suraksha Yojana scheme was introduced in our hospital since the year 2008. There is provision that second signatory is required in the Janani Suraksha Yojana account. There is no official order that the accused Sanjiwala Rao remain second signatory with me. She was kept as second signatory with me with the knowledge of the CSC in charge, Pankoi Samir Kumar Champati. As per the guidelines of Janani Suraka Yojana, ASHA workers are to bring pregnant women to PSC. Istama Begum was the ASHA worker. The beneficiary could not take the check at the time of discharge from hospital since the could not produce Xerox copy of mother-child health card. As per the guidelines, the check is issued to the mother of the child only. The mother of the child did not come to the hospital to collect the check till 25/9/2010. During the time of discharge of the patient Leila Begum on 7/9/2010, myself Sanjoy Rao, ASHA worker Istam Begum and male sweeper Bikram Naik were present. And Bikram Naik is the main witness, my lord. After the delivery of the child, no demand was made by any of the staff of her hospital, including the accused, to the patient, Leila Begum, or to her husband in my presence. After delivery of the child in the labor room, the accused came to the outdoor where I was sitting. After delivery of child, the mother and the child are shifted to the indoor room for 1 hour and thereafter they are discharged. The accused was sitting with me till the discharge of the patient, Leila Begum. After preparation of some papers in the outdoor, Leila Begum was discharged from the indoor. Leila Begum has not come to me after 4 to 5 days. Her discharge from the hospital. She was not made any oral or written complaint before me regarding demand of any illegal gratification by any staff or issuance of check.
So what this witness basically stated, what has been relied on by the London trial court, is that the accused was present with this gentleman,
Yes.
PW1,
Yes, ma'am.
right from the
Beginning.
time when the complainant's wife took admission and till she was discharged. So, and there were other persons were also present, but this doctor has not stated that there was any kind of demand from the side. Rather, she stated that in our PHC there used to be no demand. So that is no doubt, but then how these two witnesses which are relevant, that is 3 and if you come to 3, what you have elicited?
My lord, one may I pray, my lord? Lordship, kindly have glanced to page 93. The deposition of witness for defense side, Bikram Naik, who was present.
No, that's all right. You come to PW3. He is the complainant in the case, right? So he has supported. Then what he has stated, that date of demand, what he stated, it is on 7/9/2010.
25/9/2010. 7/9/2010, male child born.
Just a minute.
7/9 is the pre-demands.
So, please come to the PW3. That is page number 47.
My lord.
You see, she demanded such gratification on 7/9/2010 when my wife delivered the male child. ମନା କରୁଛନ୍ତି କଣ?
He has said the
ଆରେ
complaint.
କଣ ସେ କହୁଛି, ମୁଁ ଆପଣ ଫଟକିନି ମନା କରିଦେଲେ ନା। ମୁଁ କହିଲି ଯେ ପ୍ରଥମ ଡିମାଣ୍ଡଟା according to the complainant was made on 7/9/2010 when his wife delivered a male child in the CHC. Then what has happened? That amount was demanded was 400. No, it was demanded 500. Then it was reduced to 400 for issuance of that check. And then 2 to 3 occasions he came. It was constantly insisted. Then subsequently on 24/9/2010, She told to bring so and so on 25/9/20. So 7 ତାରିଖରୁ 24 ତାରିଖ ପର୍ଯ୍ୟନ୍ତ ବିଭିନ୍ନ ଡେଟ୍ ରେ ଡିମାଣ୍ଡ ହଉଥିଲା। ଡିମାଣ୍ଡ ଗୋଟେ ପର୍ଟିକୁଲାର ଡେଟ୍ ରେ ହେଇନି। ତେଣୁ ଆପଣ ଯୋଉ କହୁଛନ୍ତି ଡିମାଣ୍ଡ ଡେଟ୍ ଆପଣ କହୁଛନ୍ତି ନା 24 ତାରିଖ, that is not correct. Just you as per the complainant. अच्छा, same version is also there in the FIR. That it started on 7/9. It continued up to 24/9/2010 when the FIR was presented. So what the Learning Trial Court has done, that since PW1 says that he was throughout present with the accused on 7th, therefore, and his evidence is silent about any demand, so the demand cannot be accepted. But it is not a demand only for one day. It's a demand for, he says one day, the first day is 7, again he approached twice or thrice, then again he approached on 24th. Your PW1 doesn't say that on all those dates he was with the appellant.
PW1 may I submit?
अरे PW1 कौन कहला, केवल 7 तारिख दिन कथाटा कहूची। 7 तारिख पर से कहूची कि मु जेतेबेले से आसुथला मु ता पाखरे थिली,
सेटा कहना
ये ट्रायल कोर्ट कौन हेल्ड कले जे प्री डिमांड कौन पे डिसबिलीव कले? Reason is that the doctor PW1 he was present, he has not stated any about any demand, so that's why pre-demand is discarded. But in fact the complainant version, not only in the FIR but also in the during trial, is that it was not demanded only on particular date. यदि 7 तारिख दिन केवल गोटे दिन डिमांड होता ताहले matter would have been different. अच्छा, what is the charge? Let us see again. Charge demand date कौन रोज?
Page 34. That we being a public servant functioning as ANM of Maninggoda Health Center on 25/10/2010 by corrupt and illegal means of otherwise abusing your position as a public servant, obtained for yourself pecuniary advantage to the extent of ₹400 from the complainant Mehboob Hussain Khan for releasing the check amounting to ₹1400 in favor of Leila Begum, wife of the complainant under Janani Suraksha Yojana, as Leila Begum had given birth a male child on 7/9/2010 at Maninggoda Hospital and thereby committed an offence under 13(2) read with section 13(1)(d) of the PC Act 1988 and with my obedience. Secondly, that you being a public servant functioning in the above capacity in the above place on 25/10 accepted ₹400 from the complainant as gratification.
Demand date is missing from the charge. खाली कहूँ acceptance विषय पचराइछ।
the gratification other than legal remuneration as a motive for releasing the check amount in rupees 1400 in favor of Leila Begum, wife of the complainant under Janani Surekha Yojana, as Leila Begum had given birth to male child on 7/10 at Maninggoda Hospital.
There should have been their demand should have been mentioned. The charge is defective one. On the you demanded and by corrupt and illegal means accepted that. That is nothing about this demand what because those things are different. Demand, acceptance, recovery. The charge
That
is
this charge, Your Lordship is correctly saying that this charge pertains to demand made on the date of the trap. That is on demand made on the date of the trap. That is on 25th.
No, where is that word has been used? Demand. Read out any word demand if it is there. Please show me.
Pecuniary advantages.
Acceptance.
What is missing?
That word the word has been used as acceptance. All right.
The secondly, the accepted 400. And he accepted not as legal remuneration, but as illegal gratification. Secondly, second line. Lordship permits me not Section 7 of the PC Act notes, under which this charge has been framed, Section 7. It also says that whoever being on expecting to be a public servant accept and obtains or agrees to accept or attempts to obtain from any person for himself or for any other person any gratification whatever other than legal remuneration as a motive or reward for doing or forbidding to do any official work or for suing on forbidding so in excess of official function favors or display of the person rendered. So only with regard to the ingredients of acceptance other than legal remuneration as illegal gratification. It permits me Section 13 also deals with agrees and accepts any illegal gratification other than legal gratification. Section 13, 1 and D also.
Okay. মনোপত্র କୋଉଟା ଆଣିଥିଲା ମୁଁ ମନପତ୍ର କିଛି କରିନି ମୁଁ ଖାଲି SCC ଟା ବନ୍ଦ କଲି কি বলছি ଦିଟା ଆର ଇଏଟା ଦିଅ ଦିଟା ତମକୁ ଦେଇଥିଲି ପୁରା ଗୋଟେ ସାହୁ ହେରିକା ଜଜମେଣ୍ଟ କାମ କରୁଥିବ ବୋଧେ କଣ ହେଲା এটা দৌড় নয় দিও তুমি জানো সে কারণে ব্যবহার করতে কোন মতে ନା ଚାରଟା କାହିଁ ପାଇଁ ରଖୁନ ତୁମେ ପାଖରେ ହୁଁ କିଏ ଖୋଲିଥିଲା କି ହଁ समझा Your case is that some documents were wanting for which the check could not be issued.
Yes.
What are those documents?
जननी सुरक्षा योजना जो डेलीवरटा हुए जो बैंक कागज आशा दीदी मानकर जो से एंट्री करथे डेलीवरी पेशेंट बोली एंट्री करथे से डॉक्यूमेंट गुड़ा देले एएनएम कौन करिवो सेटा प्रोड्यूस करिवो से मेडिकल अफसर पाखरे ताको जननी सुरक्षा योजना गवर्नमेंट रोटा 1400 रुपीस आसी
No, that's there, but
से डॉक्यूमेंट दरकार बैंक कागज प्लस आशा दीदी जो इम्यूनाइजेशन देइथांती 9-10 मास भितर से कागज এই সব কাগজ এএনএম দিতে দেলে এএনএম সেটা দেবে সেটা সে দেই নথলা তাছাড়া দ্বিতীয় কথা সেই যে এই কোয়ার্টার ପାଇଁ କି ତାଙ୍କର ଗୋଟେ ଗଣ୍ଡଗୋଳ ଆଗରୁ ଥିଲା ସଞ୍ଜୁ ତା ନା କଣ ଗୋଟେ କି ତାଙ୍କ ଷ୍ଟାଫ ସେ କ୍ୱାର୍ଟର ପାଇଁ କି ତାକୁ ଫସେଇ ଦେଇଛି ଆଜ୍ଞା
yes, Mr. I have heard you. Anything else you want to say?
No, Judge, I'll place only one line from the judgment of the Honorable Supreme Court.
No, here is a case where both the decoy and the overhearing witness they have supported the prosecution case.
Exactly.
And apart from that, the recovery is also there.
Correct.
And hand was turned, changed the color, turned to pink, and that was also finding is there from the C report.
Absolutely.
So,
if a permit, my lords,
yeah,
in one line, my lords, a conjoint reading of all the trustworthy evidence of the decoy, 1, the shadow witness, 2, and the TLO with regard to the factum of demand, 2, voluntary acceptance of illegal gratification, not the legal remuneration, 3, and the recovery of the 1010 money from the left hand of the accused lords, unequivocally indicates there was a demand, there was an acceptance, and there has been, and lords and the ground, and in fact, so far if the demand and acceptance and recovery is absolutely, based on the cause and evidence on records, lords, and the same has been brushed aside by the London trial courts, lords, and the accused was later of lords on flimsy grounds, on 4 grounds. 1, why the right hand, how the right hand was not found again pink, and found that why he didn't, the accused didn't inform to the concerned doctors, and there was no pre-demands, and there was another ground. These are all grounds, my lord, which are not german to the evidence on records, my lord. So any findings not based on the evidence, it also amounts to perversity, my lords. And the evidence on records, my lord, are so mounting, my lords, and the findings are contradictory with each other and inconsistent, and absolutely bristling with contradictions, my lords, and resulting in the perversity, my lords. If a lordship permits, my lord, at the end of the day, my lords, if we both will prepare in a better way to give lordship better assistance, then lordship can take out some matter, or lordship may close the matter. I will file the decision. And with regard to the decision,
I just want some clarification. This, where have you brought those materials that these are the particular documents which are required for issuance of a check? What are those? You said na bank documents, this, that. Oh, so evidence. Where is the evidence? ଜଣେ ସ୍ତ୍ରୀ ଲୋକ ଆପଣଙ୍କ ହସ୍ପିଟାଲରେ ପିଲା ଡେଲିଭରି କରିଛି 7 ତାରିଖ ଦିନ, ସିଏ ହଉଛି ସେଇ ଲୋକାଲିଟିର, ତେଣୁ ସରକାରଙ୍କର ସ୍କିମ୍ ଅଛି, ତାକୁ 1400 ଟଙ୍କା ଚେକ୍ ହ୍ୟାଣ୍ଡ ଓଭର କରିବେ। ତ ଚେକ୍ ହ୍ୟାଣ୍ଡ ଓଭର କଲେ ସିଏ ତା ଆକାଉଣ୍ଟରେ ଡିପୋଜିଟ୍ କରିବ, ତାପରେ ସିଏ ନବ। ତ ଯିଏ ପିଲା ଜନ୍ମ କରୁଛି ସିଏ ଆଭେଲେବୁଲ ଅଛି, ତାର ଗାର୍ଡିଆନ ଅର୍ଥାତ ତା ସ୍ୱାମୀ କମ୍ପ୍ଲେନାଣ୍ଟ ଆଭେଲେବୁଲ ଅଛି, ପିଲା ଜନ୍ମ କରିଛି, ତା ପାଇଁ ଆପଣ ଯୋଉ କହୁଛନ୍ତି ସେ ଏ ଡକୁମେଣ୍ଟ ଦରକାର, ସେ ଡକୁମେଣ୍ଟ ଦରକାର, ଏଗୁଡାକ ନଦେଲେ ଚେକ୍ ଇସ୍ୟୁ ହେଇପାରିବନି। ହଁ, ତାମାନେ ସେ ବାରମ୍ବାର ଦୌଡିବାକୁ ପଡିବ। ଆପଣ ଯୋଉ ପ୍ରୋସେସ କହୁଛନ୍ତି ସେ ବାରମ୍ବାର ଦୌଡିବାକୁ ପଡିବ ତାକୁ। ତେଣୁ ସେ କୋଉଠି ଅଛି ଯେ ଏଇ ଡକୁମେଣ୍ଟ ନଦେଲେ ହଁ ସେଇ ଡକୁମେଣ୍ଟ ଆପଣ ଯୋଉଟା କହୁଛନ୍ତି ଯେ ଇଫ୍ ଦେର୍ ଇଜ ସଚ୍ ଏଭିଡେନ୍ସ ଦ୍ୟାଟ୍ ୟେସ୍ ଏଇ ଡକୁମେଣ୍ଟ ଗୁଡାକ ଦରକାର ଯୋଉଟା କି ସେ ଫେଲ୍ କଲା ଟୁ ପ୍ରଡ୍ୟୁସ୍ ମ୍ୟାଟର ଇଜ ଡିଫରେଣ୍ଟ. So first of all, let us find out that where have you brought out that this A, B, C are the documents which are required for issuance of check under that scheme. Because you are also not disputing, that is also the prosecution case, that under such scheme, a lady is entitled to get 1,400 if she delivers a child, right?
Yes.
Question is that it was not done in the case of the complainant's wife. Even though she was admitted, she delivered a child, discharged on a particular date, that is on 7/9/2010.
If Lordship permits, may I add one line, my Lord? But on the other side of the coin, on 25th, my Lords, on the payment of that particular illegal gratification, Lord, it was expedited, and on the same day, my Lord, they got out from that PSC with the check. Bereft of the fact of whether the documents were mandatorily required, my Lord, to get this particular benefits granted to them by the government scheme.
My Lord, with humble submission, my Lord, may I pray? Page 93, one witness that the Bikram Naik statement I will read out, my Lord.
Kuda?
Page 93, Bikram Naik statement.
Semti hela habani. Apono prepare a note. These are the documents which are required. Apono oda plea nahi chandi na. Apono plea con. Please come to that PW3's evidence.
Yes.
जोटा कि आपनकर स्टार विटनेस on behalf of the prosecution, you come to the page 58. 58, the your last question in the cross examination. That is your suggestion. That it is not a fact that whenever I made the accused, she always advised to produce the required document for issuance of check. Hello?
Yes.
So that was the main reason why you say that it could have been issued on 7th itself or even thereafter, but this that was not produced. That is why the delay. It is not on account of bribe, non-payment of bribe. That is exactly your case.
Yes.
So let us know that what are those required documents according to you. What evidence you have brought out that these are the required documents which the PW3 failed to produce, for which the issuance of check got delayed. So it is already been partnered, so it will come next week. So I will close the case on that day. So,
Proceed call on 17th August, my Lord. 17th August.
Why?
I will discuss something. 2 days, 3.
All right, hard. Mr. Sangram Das, Lenin, Standing Counsel for the Vigilance Department. And you are Mr.
Makeup, Sarachandra Makeup.
S.C. Makeup, Lenin Counsel for the respondent. On consensus of both the parties, list this matter on 16th of 17th of August 2023. The Land Council for both the parties submit that they will prepare written note of argument and also submit memo of citation, and therefore the matter may be taken off a week after. On consensus of both the parties, list this matter on 17th August 2023. Hello? Don't take time, and I will conclude the hearing on that day.
Yes,
yes. Who else are present? What is your item? Please come to the mic.
My lord, item 46. It is specially assigned to my lords. No, it was in the serial number 15 and 16 also, and 18.
but thereafter it is also delayed as a non-teaching staff of an institution. My lord, that is delayed, so he is not getting the pension. So that's why.
Just a minute. 40?
46. Specifically, in 2 occasions, I draw my lord's attention. My lordship assured that it will come, but thereafter it has been.
46, it's a case of conviction.
Conviction, my lord. That is
But for that, who is to do it?
I am that. I have been assigned this. That's what record is not there for the time being.
All right. Paperwork has been prepared. You have not received the paperwork.
No, my lord.
So get the paperwork, get ready. He is
paperwork already
Ready.
Paperwork already accepted by the
we have also received.
No. He has not received.
Copy of it.
already served.
So there are two, Ajit appears, there are 2 appeals.
2 appeals, my lord. I am for a assistant junior. I am for a clerk, junior assistant, and he is also for the teacher.
510 is my appeal. 512 is my appeal. Second item. I am appearing for the one of the appellants. And paperwork already on record. I have already another copy of the paperwork already served my lord friend appearing for the vigilance. Let it be any next week any top of the list.
No, it is there in the list.
Yes, it's
But
there.
now he is not ready. Now it is 3:30. I can take up another matter also. And make it
Next week or any convenient week, my lord.
unless both. Now you see the state council is also not there.
If it will be convenient any other day, my lord's convenience is there.
What are these item number 3 ta kon?
It's a vigilance matter.
3 type vigilance matter.
Yes. In fact, 90% of the list covers vigilance matters.
କୋର୍ଟଟା ତ ସେ କଣ ଆସନ୍ତା ସପ୍ତାହରେ କରିବେ ବୋଲି କହୁଥିଲେ। 5ଟା ତ ଭିଜିଲାନ୍ସ ମ୍ୟାଟର ନୁହେଁ ବୋଧେ। So এটা কি অফেন্স?
So 1, 3, and 4 are vigilance matter. 1 is of course completed. 3 and 4 is a vigilance matter. Then from 25 onwards there is vigilance matter. Item 5 to 24.
এটা 323 ରେ 6 ମାସ ହେଇଛି। ଏ ଡାକିଲ ସେ ଷ୍ଟେଟ କାଉନ୍ସିଲ।
I am informed.
ପଳେଇ ଯାଉଛନ୍ତି ଘରକୁ ପଳେଇ ଯାଉଛନ୍ତି ନା କଣ?
ଚାହୁଁଛନ୍ତି କି ନା
So Das is on his way. He's just
Okay. पेपर उठा करवा ଏଇଟା Yes, this item number 5.
Malad.
Now nobody is appearing from it's a 323. As I find 6 months sentence is there. So
Lawn senior Mr. Mishra is appearing, Malad.
In which item?
Item 5, Malad. Mr. Mishra is assigned, Malad.
No, from the state side.
State side.
No, I'm telling you about from the appellant side.
Appellant side. Yes, appeal, my lord, that lordship may direct for engagement upon counsel, because appeal cannot be.
No, that is the reason. Otherwise, I would have
My lord.
Case of conviction.
My lord.
जो ये देखिलो संजीत महांती अछनी माने सीनियर एडवोकेट संजीत महांती
Appellant. I don't think.
Mr. Das, Mr. Sanjit Mahanti, senior advocate, is appearing in this case. Has filed appearance memo as it appears from the cause list. That's why I ascertained whether it is audible. Mr. Sanjit Mahanti is appearing in item number 5. It's a case of conviction under section 323 and 6 months is the. But the question is that he is an employee of Hindustan Aeronautic Limited. So maybe that if the conviction remains, then there may be some problem. So that is why he has engaged perhaps, even though it's a case of 323 conviction and 6 months RI. So you just intimate that so that it can be taken off if it is possible. Next week, ma'am. Otherwise, if he can join, it is time till time, so there is no problem. If anyone can let him know that. May I ask now? Yes, you can.
Upon conviction, he must have been terminated. Upon conviction also, he must have been terminated.
I do not know exactly the council making. So he was acquitted of the charge under 3 SC/ST Act, but found guilty under 323. So
any conviction that is
no, that is moral turpitude. Helles mane ye korchanti. 323 ta they may not. Nobody knows that what is happening.
No, Lord, in service level, once any order is order of conviction is passed in the
His counsel can say whether he has been.
In appeal, my lord, that will be.
So that is why it cannot be. You just suggested for engagement of an amicus.
Sorry, I could not follow Mr. Sanjit Mahanti.
No, amicus curiae once you will just we can dispose of one matter. But suppose the amicus curiae, learned amicus curiae couldn't present the case properly because he doesn't know that what is the importance of this.
Yes. That is not upon other accused, like other accused persons. He's an employee, it should be taken carefully.
323 even he can be let out with fine also, but question is that once the conviction remains, if it has got some other effect, so it has to be dealt carefully. That means it is to be properly argued and so decided. So.
I have not seen the list for that time.
No, that's all.
My lord, I talked to Mr. Mahanti, my lord. He told that it is 2001 year. So let it next week he will go to the.
Okay.
So exactly say could not recollect the. Yeah.
No, you have communicated that, so it will be there in the list. Any other Land Council item 6? These are not vigilance matter. Item 6 ta kon ka charge achi?
6 is conviction on 498 and 304B.
498 304B. So who is the council? L Samantra ta apno ye seputu paleilani. Se kagu deichanti ka? Ki buझुची tankara.
Chamber junior କରୁଛନ୍ତି they are doing
जे କରୁଛନ୍ତି
ମୁଁ କହିଦଉଛି
My lord, previously Mr. Das also received the paper book. So he also.
Your matter will be taken up next week. Why are you? He's ready to do the matter. You are insisting. How can it be? He has not gone through the brief. Yes.
I talked to the junior of Mr. Samantra. His uncle just expired. He went to that. So he told that let it next week. I'll conduct to it.
Mr. Das, the problem is that
I understand.
They are reported that 20-25 years appeals are pending in High Court.
Basically, the some here in morning or they wanted to take
because these are regular appeals, and I cannot engage because we do not know that what is like in 323K appeals.
It should be.
He's in. Suppose if he once his conviction is upheld, he may lose the service.
So will not get any benefit.
Right. So question is that That is the reason why these old appeals have been, there is some instruction coming from that side. So that is why. And these are all 2001 appeal. You see,
1 and 2.
huh?
1 and 2.
So they are. You see, DP Dhar, so many matters. In this page, in page number 5, DP Dhar 1, 2, 3, 4. He has got 4 matters. Mr. Devasis Panda has got 3 matters.
Because the vigilance matter is going on, so they thought that it will no matter will be taken on. That's why, madam.
They should know, get
Yes, madam.
ready at least.
Madam.
Make a call to Mr. DP Dhar.
Madam.
Why his associates are not there?
I am calling you also, madam.
What is this, sir?
The junior is coming, madam. Last 3 weeks, continuously from the beginning, the vigilance matter is going on, madam.
So it's all right. We had the vigilance matter up to almost 315. But they took time to prepare a note. So I cannot insist them that you finish it. So
that's why others council. I mean,
sometimes they come and make a mention our late hour matter. I say that you wait. Maybe that some matter may end and we can take up one matter. Once it is made part-hard, it will come to the top. Nobody has patience. Either you take up in the first hour or we'll go home. No, that is not the thing. Now he will come, you see, the associate will come and say that we are not aware that matter. ବର୍ତ୍ତମାନ ସିରିଜ କରିକିନି ସବୁ ଗୁଡାକ ବେଲ୍ ଅର୍ଡର ରିକଲ୍ କରିଦବ 7 341 325 34 अच्छा
যদুনাথ মুর্মু
যদুনাথ মুর্মু ময়ূরভঞ্জ কেস
লেন পটেল
political person or what? What is the next one? 8 7 is here, 3 months. 9. $304 part 2, 7 years. Nityananda Beoria. 24. No, next item. 25.
My lord.
I'm sorry, Your Lordship. 8 and 11, Your Lordship. I will do it next week, Your Lordship.
No, I'll authorize, I'll recall the bail order and you will argue the matter next week.
Lords, in 15, I have not yet received the paper book. That is my problem. I have 2 other matters, my lords. If your lordship wants, we can take up item 35, my lords.
It's a vigilance matter.
Yes.
This,
Item 9 is one of the matter.
9.
Item 9
is also, no, 9 is of Devasnanda.
9 is Devasnanda.
15 is the
15?
15.
15.
Yes, 15 I don't have paper book, but I have paper book in 35 and 77.
35
That is CBI, my lords.
CBI, Mr. Nayak is not there. Okay. In other matter, you are telling, in any case where state is a party, Mr.
No, state is not a party. So far as state party, that is item 109, I believe. But I think the petitioner is no longer alive. Your lordship has to ask for a report to be obtained.
No, nobody is interested to continue the appeal.
109, I have got no contact, my lords, also with the clients, my lords. If Mr. Naik, if Mr. Das can get a report, my lords, from the local police, my lords.
109.
Yes, my lords. That's a revision against a conviction in a Dakaiti case.
Single appellant, 109 dekla.
Single
petitioner.
Aye. Single pitch.
Revision petition. Yes, single petitioner. So, Mr. Just you.
I am appearing.
No, you are appearing. You can take instruction from the concerned police station whether this person is alive or not. That much you just want. I'm handing over a copy to you. Mr. Panda says that he has no contact, perhaps might have died.
Because he was pretty middle-aged when I started practice.
Right, see, that is, so let us see that.
I'll take it.
Item number 109 tar likhi janji. The matter was called. Mr. Devasis Panda, Land Council, appearing for the petitioner, submits that in spite of his best effort, he is unable to contact the petitioner. And in view of the age of the petitioner, let the Land Council for the state be directed to obtain instruction about the status of the petitioner. Land Council for the state seeks some time to obtain the same. Let status of the petitioner be obtained from the inspector in charge of Chaudhar police station. A free copy of the order be handed over to the Land Council for the state. So, Mr. Bhall's matter, 4 matters are there in page number 5. So you do, this is item number 8 is there, in which 2 appeals are there. Then 11 is another. Then again 13 is another. And
15, I'll get a copy of the paper book and get ready. Next.
Okay, Mr. D. Nayak matter is there also in item number 14. So the Mr. Counsel, you see, the problem is that it is told